City of Asheville Board of Adjustment meeting. My name is Suzanne Godsey, and I am chair of this board. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance. We are authorized to hear requests for variances from the city's UDO, appeals from final determinations made by city officials charged with enforcement of the city's UDO, requests for reasonable accommodations, and other requests as may be provided in the city's ordinances. Our first agenda item is a review and adoption of the minutes and findings of fact and conclusions of law of the June 23rd, 2025 regular meeting. Has anyone looked at those, and is there a motion?
Motion to accept.
Second.
Okay, all in favor say aye.
Aye. Aye.
Great. We now begin the evidentiary hearings for the cases listed on the agenda. In hearing cases, the board conducts a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from some other types of land use decisions like rezoning cases, which are legislative in nature. This board's decisions are constrained by the standards in the city's ordinance and the facts presented at the hearing. The board hears and considers evidence presented at the hearing and applies the standards set forth in state law and the city's ordinance. The board must base its decisions upon competent material and substantial evidence presented at the hearing. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Participation is limited. The meeting is open to the public. Everyone is welcome to watch. Parties have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Witnesses may testify as to facts to which they are competent to testify, so long as those facts relate to the legal standards. In addition, lay or non-expert witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts on traffic safety. For variance requests, a 4/5 vote of the board is required to grant the variance. For all other hearings and matters, including the adoption of the minutes, the decision will be made by a simple majority vote of the board. Witnesses must swear or affirm their testimony. At this time, we will administer the oath for all individuals who intend to provide witness testimony. If you will please stand and raise your right hand if you plan to provide testimony.
Should we just do it at I'm a lawyer, I represent the second matter on the board. Can we just call our witnesses at the appropriate time if you want to swear them in now?
Let's swear everyone in now so we don't have to do it in the middle. That's how we generally do it, is swear everyone for all cases at the same time.
So we're actually not sure we're going to call any witnesses. Can we swear people in if we need to call them?
I would just say if anyone may be called or you think you want to speak on behalf of any of these, go ahead and plan to swear or affirm. That will save some time on the back end. Thank you so much. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? Thank you so much. Our first case is a variance, and the petitioner, Skylar Levinson, is requesting variance to the setback standards in Section 783F5, RS4, Residential Single Family Medium Density District setback standards of the Unified Development Ordinance. The applicant is seeking relief from the required front, side, and rear setback standards. The property is known as 9999 Campground Road and PIN number 9668181427. Madeline Stone will be presenting the case this afternoon.
Thank you, Chair, Commissioners. Madeline Stone, Urban Planner 1, Planning and Urban Design Department. Today we're going to be looking at 9999 Campground Road. The petitioner is requesting a variance from the standards found in Section 7-8-3, RS4 Residential Single Family Medium Density District of the UDO to allow for construction of a single family dwelling. The RS4 setback standards are a 25-foot front setback, a side setback of 10 feet, and a rear setback of 25 feet. This variance will allow a reduced front setback of 6 feet, a rear setback of 12 feet, and one side setback reduction of 6 feet to construct a 720 square foot home. The lot is substandard, measuring 43 feet by 99 feet with an area of 4,791.6, which is approximately 59.9% of the 8,000 square foot minimum, which is required in the RS4 zone. Here's an overview photo of the lot. It is located between 41 Campground Road and 43 Campground Road. So the applicant is requesting a 6-foot reduced front setback, which would be a 76% variance, a 6-foot side setback, which would be a 40% variance, and a 12-foot rear setback, which would be 52% variance. And 9999 Campground is zoned RS4 as well as the surrounding parcels. For some background, the subject parcel is a .11 acre residential lot located in East Asheville between Bull Mountain and Tunnel Road. All adjacent lots contain a single-family home. This parcel is landlocked with a shared driveway coming off of Campground Road, which connects 41, 9999, and 43 Campground Road. The lot was created in 1945, which predates Section 712 of the city's UDO. The underlining zoning for this parcel is residential single-family medium-density district, which has required front and rear setback of 25 feet and a side setback of 10 feet. The combination of short lot depth, substandard lot size, and the required setback creates a small building footprint, and the proposed single-family home will be oriented to face Campground Road. The applicants do plan to retain existing vegetation and a tree line along the northwest property line, and also plan to construct a 6-foot tall fence along the southeast property line to provide a buffer for other residents on Campground Road. Here are some site photos. On the left is the shared driveway that connects from Campground Road up to 43 Campground Road. On the right, where that gravel starts, is essentially where the 9999 begins. It does cross a little bit over on the other side of the shared driveway. The photo on the left is almost a lot in its entirety. It does expand past that tree line and some of that vegetation and cuts over a little bit. That shows on the photo on the right is where it extends over past those trash cans. And here's kind of an overview of what the lot looks like. The petitioner does own the property at 43 Campground Road, which is the house visible in that photo, and it extends through this like dirt area / gravel over to the vegetation on the left. Here is the site plan that the applicant has provided. As you can see, the home will be to the southern side of the property, which will have those 6-foot reduced front setback on the northwest property line. There is that existing tree line that they are maintaining, as well as the existing vegetation. They are going to be retaining that magnolia tree as well that was in the previous photos, and constructing a 6-foot tall fence along the southeast property line as well as the southwest property line. So here are just some more site plans. As you can see on the right, the shared driveway cuts all the way up to 43 Campground Road. In conclusion, the subject property is zoned RS4 with a minimum lot size of 8,000 square feet and required front and rear setbacks of 25 feet and a side setback of 10 feet. The combination of lot depth, substandard lot size, and required setbacks results in a small building envelope. The proposed unit is 720 square feet, and the applicants will be retaining existing vegetation and constructing a fence to provide a buffer for other residents on Campground Road. Happy to answer any questions. The applicant is also here for further questions as well.
Does anyone have any questions for Madeline? It doesn't seem like anyone does at this time, Madeline. We might call you back up if we do. Do the applicants have a presentation or any additional testimony for the board to consider? Are they here? Hi. Would you like to come to the board and come to the microphone and state your name, please? Sure. Thanks.
Hi, I'm Skylar Levinson. I don't have much to add to that, other than what's there. But if you have any questions, I'm happy to answer them.
I have a quick question.
Yeah.
What hardship has this created for you?
Well, the current setbacks don't allow for any building to be built. It's like they overlap. This is actually a negative building footprint. So the hardship would be to construct any livable dwelling
So,
on the lot.
so my understanding is additional building of property?
It would be the first building on this parcel. Yes. So it would be the proposed 24 by 30 home.
So you own the property that encompasses the shared driveway?
Yes.
And are you planning to list this property to sell it? I guess
No, it's my mother-in-law and my wife and I bought the two. So the intention at first was to build something there and that is the plan.
So this may be a question for staff. So I guess exploring the opportunity for it to be an accessory dwelling unit isn't applicable because size of
Front.
the, okay.
Again, an accessory dwelling unit implies the existence of a primary dwelling unit. There are no structures on the existing lot. The photos Madeline had shown, I take responsibility for. I took those when I was posting the sign. I am Asheville's worst photographer. Any house or structure you saw is not on the property that was facing northeast. So this is a blank substandard lot that defined by the UDO. It was established in 1945. So this lot that Madeline has put up in Exhibit 1 is showing the lot. There are no structures there, so it can't be an accessory dwelling unit because it is not, you are not allowed to have that on a lot without first establishing a primary structure, and that's what the applicant seeks to do. So this is a home. This is on its own lot. It is correct to say that they own 43 campground. This is unaddressed, and it's the small lot in front. But the photo had mistakenly captured the house and back.
I guess I'm just trying to ascertain, like, if they were to recombine the property and have a primary structure, then they would then be able to have an ADU, and that could be the ADU, or it could be something that, like financing or something like that, that I'm not even thinking of. I was just curious as to if that option was explored.
And if I may, I wasn't sure you were posing that towards, but I did meet, Madeline was off on vacation. Tyler and I met with the applicants there, and that was something they had explored. But I would also invite legal's opinion here. This seems to be largely hypothetical in that what is before us today are the building and development rights of this lot, which still do exist. It's Hog Creek, it's Asheville, of course. There's steep slopes and other challenges which do make the ADU difficult, but it is not within the purview of this case because this is a standalone lot which does have development rights, and that's what is there today.
And that shared driveway would be compliant for fighting fire because it's just two lots and they'd be coming up to one house or the other house, and so, okay. Just wanted to make sure we weren't creating another kind of problem somewhere down the line. Okay. All right, does anyone have any other questions for the applicant, or do you have anything else you want to share with the board?
I'll just share that I think this spot where I proposed the home to be built is the most visually appealing to all parties. And I did speak with my neighbor on the northwest side, and their main concern is the roots of the trees, and so we're getting an arborist to look at that, make sure. Other than that, there's good relations.
Okay, great. Thank you so much.
Yeah, thank you.
If we have any other questions, we'll call you back up. Thanks. Is anyone from the public here that would like to give expert testimony or testimony from residents with standing? And I see none. Okay, board, is there any discussion or a motion?
Motion approved.
Okay, I have a motion from Elliot to approve. Can I get a second?
I'll second.
Great. Board members, when I say your name, will you please say aye or nay? Elliot Smith? John Michael Cletus?
Aye.
Annette Wise? James Warnall? Nay. Suzanne Godsey is an aye. Variance passes. Thank you so much. Okay, now we're going to move to our administrative appeals, which I'm expecting most of you are here for. We have various petitioners represented by Brian Golden from the Van Winkle Law Firm seek to appeal Unified Development Ordinance determination made by Planning and Urban Design Assistant Director Chris Collins, and that was dated from February 21st, 2025. And City Assistant Attorney Carly Gillingham will be presenting the case.
Yes, and before we get started here, I just want to lay out a few housekeeping items. So I'm representing the city for this case through the planning department. So I am not advising the BOA on this case. I'm taking off my legal advisor to the BOA hat, and I'm handing it to Mr. Ron Sneed, who will be advising you for this matter. So please direct any procedural or legal questions to Mr. Sneed for this matter. Per the Board of Adjustments Rules of Procedure, I'm just going to start out with asking Mr. Chris Collins, who is a staff member who issued the determination that is subject to this appeal, to give a really quick introduction. After that, I think we'll move on to anyone who has any motions pending for the board and anyone seeking standing. And we'll hear those items, and then you will hear from the appellant, represented by Mr. Golden. And then the city will present its case, and then anyone with standing. So with that, we'll hand it off to Chris to give a really quick introduction about why we're here. We're not going into the city's case or legal arguments as of yet, just a real quick intro. And then we'll move on to standing and motions.
Okay, good afternoon, Madam Chair and Board. I'm Chris Collins, the Assistant Director of the city's Planning and Urban Design Department, and I'm familiar with these mics, so that's why I'm bending over so far so that you can hear me. Going to give you a quick introduction of what you're going to hear today. The subject of this appeal is a development at 17 North Market Street. And just check my notes as I go. Where an administrative approval was granted to develop condominiums at an existing building with an expansion. So the appeal today is of an administrative determination that I issued on behalf of the Planning and Urban Design Department, that those units are legally permitted to operate as short-term rentals. That's the paraphrase of a longer letter. At the time this application originally came in, and we're talking December of 2017, the ordinance did allow for the operation of short-term rentals within the Central Business District zoning district, which you'll hear called many times today, I'm sure, the CBD zoning district. It is true that in January of 2018, the ordinance changed. So you see that time frame is close to disallow some of those uses within the CBD zoning district. That was, you'll hear about Ordinance 4637 that led to that change. And there were some notices of violation issued in subsequent years for the operation of those short-term rental units based on, at that time, observed or thought of violation for operating the short-term rental units before the non-conforming use was presented to staff. After receiving appeals for those notices of violation, city staff looked into the situation and took a closer look and determined, based on the evidence supplied by the applicant after receiving those notices of violation, and by the virtue of what's called permit choice and vested rights statutes, which are held by the General Legislature of North Carolina, things we have to do, right? That the timing of their application that I just described, coming in 2017 before the 2018 ordinance that, for lack of a better word, banned those short-term rental uses in the CBD, allowed them to operate within that 2017 condition that was present when they applied. So that's kind of summing that up. The application came in about a month before the ordinance changed. When that happens, we have state laws called permit choice that say the applicant can choose which ordinance to comply with, and that's what happened in this case. Now, at this point, other owners within the building have appealed that zoning determination. which was an actual letter we issued, and that's why we are here today before the board.
So anyone who has any motions or is seeking standing?
Well, if I may, Brian Golden, I represent the appellant in this matter. I would think that they would probably need to identify who their clients are, whether or not they have standing in order to be able to submit whatever motion it is. I haven't seen the motion.
The first motion is for standing.
There we
So-
go. I just wanted to make sure that we all are on the same.
Just, yeah.
Fair enough.
All right, my name is Jesse Swords. I'm an attorney with Allen, Stahl, and Kilbourne. I'm here with Brandon from my office and Bo. We represent the owners of units 100, 101, 102, 103, 200, 201, 202, 301, 302, and 303 of 17 North Market Street. And the first motion is motion for standing. The statutes provide standing to participate in this type of hearing to anyone with an ownership interest in the property that is affected by the decision. That's under 160D-1402 and 160D-406.
Mr. Sneed, do we need to make a motion to accept these?
Or to, I guess, find that in fact his clients do have standing to proceed, if that's your finding.
So there were a total of 5 condos, 5 people, 5 units?
Actually, we represent 10 units.
10. How many units total are in 17 North Market Street? Do we know?
12, I think.
Or
13. 13. I'm going to go with 13.
13, all right, 13 total. All right, there are 13 total units in this building, and 10 are being represented by Jesse Swords and his associates. Does the board agree that these 10 property owners have standing?
Yes.
Okay, great. All right.
Okay. The second motion is a motion to dismiss Sam and Rosemary Elias as parties to the appeal. I'm going to hand out the written motion that also has an affidavit by Sam and Rosemary Elias attached to it. So essentially, the appeal filing itself was only signed by Kenneth and Joan Pierce, who are in Unit 402. Samuel and Rosemary Elias are or were plaintiffs in a related lawsuit whose names were put on the appeal, but they did not, as the affidavit states, they do not have any objection to other unit owners using their units as short-term rentals. They do not agree with the position asserted by the appellants in this matter, and they neither intended to join this appeal nor authorized it to be filed on their behalf. So we're simply moving to dismiss them as parties to this appeal.
Mr. Sneed, do we need to do anything or just acknowledge that they are not part of this?
Just find that they are dismissed from this action.
Do we need to state that for the record, or?
So they are now part of the record. You want the record to reflect they are no longer a party.
And is that something we need to vote on, or is that something we can
I
state?
think it's necessary. They have the right to withdraw, but for the record, it wouldn't hurt if you either announce that they have a right to withdraw and that's recognized, or the vote, or if you vote on it, either one works. Just get it in the record that they're on the parties.
Okay, so based off of this notarized document, I would say that Samuel Elias and Rosemary Elias can certainly not be a part of this and not be a petitioner in this matter. Is that sufficient? All right, thanks.
And I have a third motion, which is we have a memorandum of law in support of the city's position, which we would like to submit to the board. Obviously, we'll give a copy to Mr. Golden as well. It just lays out our legal position, and there are a couple of attachments as well.
Mr. Sneed, do we need to acknowledge that we have received this memorandum?
Just a note that it's been accepted.
Okay, so noted.
Thank you. That's our motions at this time.
Okay, so I believe we're going to Mrs. Gillingham for, is it your turn to come
No,
up? or-
anyone else withstanding, if there is anyone
Oh,
else? And then the appellant will go, or the applicant.
Okay, all right. Does anyone else need to come up for standing? I don't see anyone else. Okay, good. All right, so now we are waiting for the appellant to come up?
Yes, and it may take me, you're welcome, sorry. It may take me just a minute to plug my computer in, exchange some cords with Mr. Swartz, and get it set up so that you all can see it on the screen.
Okay.
Do you have a minute for that? Can I- Thank you.
No, we just need to acknowledge it.
Bring it back charging. Sorry, just keeping everybody alive. Oh, no, that's- It seemed a little quiet in here. Sam can attest that it didn't take this long. Came in, plugged right in, so if you coffee.
Yeah. First rule of technology, never works when more people are watching.
Yeah. And if you're like me, I break into a cold sweat when I have to do anything with technology. I know, I'm like chicken.
Would you prefer to email it to us and we can get it up on ours?
Yeah, because everybody was watching. Thank you for your patience with that. I apologize. Brief introduction. My name is Brian Golden. I'm an attorney at Van Winkle Law Firm. I have one of my law partners here, Taylor Osborne. She's assisting me in this matter. We represent the balance of the two homeowners, Christian and Kim Oliver and Ken and Joan Pierce. Ken and Joan Pierce are in the background as it relates to this appeal. As Mr. Collins indicated, he had made a zoning determination. My clients, who are residents in 17 North Market Street, appealed that determination, and that's why we are here today. So as the appellants, we get the opportunity to go first pursuant to your rules of procedure. Just a little housekeeping matter. We'll have 3 witnesses to call. We intend to call Mr. Chris Collins, walk him through the zoning determination letter. We have an individual, Mr. Gerald Green, who we will call to offer opinion testimony. And then we have Mr. You've been here long enough, you may very well know Mr. Green. And then we'll have Mr. Pierce come in and finish. And so thank you again for the opportunity to present our case. And with that, we would call Mr. Chris Collins to the stand.
This is cities.
Mr. Collins, I'm sure the board knows who you are, but if you can you please identify yourself and your profession for the members of the board?
Certainly. I'm Chris Collins. I am an urban planner who currently serves as the Assistant Director of the Planning and Urban Design Department for the City of Asheville.
And how long have you been employed with the city of Asheville?
We're on 2025, so we're coming up on 13 years. It's been 12, coming up on 13.
Tell the board a little bit about your training and background as it relates to your job, duties, and responsibilities here in Asheville.
Sure. So I possess a master's degree in urban planning and roughly 21 years of land use planning experience at varying sizes of municipalities and combined governments throughout the southeastern United States. I also possess a certificate from the American Institute of Certified Planners, which is our highest certificate issuing authority for the urban planning field.
Let me interrupt. Mr. Collins, if it makes sense for you to have a seat to be able to adjust that microphone, I don't want you to have back problems at the end of this. We all know that people that are not as short as me have issues with these microphones these days, so, okay.
Feels odd to sit at this podium, but we'll do it today.
And will you tell the board, will you explain to the board what your duties and responsibilities are and have been with the city of Asheville?
Sure. I was originally hired on as a division manager within the city's Development Services Department. Let's make this a long story short. Originally, what functions are now within the Planning and Urban Design Department were split between Planning and Urban Design and Development Services. So zoning review for developments was housed within Development Services at that time. That was the division of the department that I was responsible for leading up until, sorry, like a lot of people in the room, the Helene blip has messed up my dates. So up until 2023, when the departments merged and became what is now Planning and Urban Design. Later that year, my position, I received a promotion to Assistant Director of the newly merged Planning and Urban Design Department, where my duties continued to involve supervision of our daily zoning plan review, development plan review activities, and of course added new activities such as participating in the directorship of the department, administrative tasks, management tasks, things such as that. But the key is, my position originally was the supervision of the development plan review for zoning, actually at that time for stormwater and erosion control as well. And now I have carried forward with the overall supervision of the development plan review for zoning.
And as part of your duties and responsibilities in your position with the city, are you tasked with reviewing certain aspects of permits and approving those aspects of permits?
I am tasked with the supervision of staff, and we have staff dedicated to that function. I'm going to give you an approximate number so I don't go through a head count in my head right now. I think we have roughly 11 to 12 staff members tasked with reviewing and issuing those permits under my supervision and under the supervision of people under my supervision.
And part of that, again, that responsibilities are to, while we're here, make zoning determinations as it relates to, I guess, questions of application related to the UDO and maybe North Carolina law?
Generally, the UDO, that's the Unified Development Ordinance. I know you're all familiar with it. And generally applying that as it relates to North Carolina general statutes, which we must stay within the realm of while administering the provisions of the UDO.
And do you, as part of your duties and responsibilities, do you go to continuing, I was going to say legal education, but continuing urban planning education? What do you do to make sure that you maintain current with your licensure?
Aside from the fact that I'm a huge planning nerd and read things most people wouldn't want to, being a certified planner with the American Institute of Certified Planners, as referenced before, does carry with it a continuing education requirement that I receive 36, I believe it's 36 now, hours of certified continuing education biannually. That also further has specified specialty areas within it, including things like sustainability. More germane to this, does include a law specialty where certain credits must be obtained to stay current on those items as well.
And have you gone and taken those continuing education classes on, I think you just said, law certification?
Yes.
And at this time, and I'm just going to do it just out of an abundance of caution, we would just ask that Mr. Collins be qualified as an expert in urban planning as it relates to the city of Asheville's UDO.
I'm going to object to the extent that Mr. Collins is being asked to testify as to conclusions of law. The proper interpretation of ordinances and statutes is a matter of law, which is, evaluated de novo upon appeal. Not all facts are going to be relevant here. So to the extent that he's talking about the ultimate issues of law, I don't think it's proper to qualify him as an expert, but we're certainly happy to have his testimony.
So, and I guess I qualified it, but maybe Mr. Swartz misunderstood me. I had indicated that we would qualify him as an expert out of an abundance of caution in urban planning as it relates to what he does here with the city of Asheville. He doesn't have a lot of duty. Of course, we wouldn't ask him to testify about how he legally interprets anything. And so if he is up here talking about why he made his decision, and in his opinion, that's the correct decision, I think he would need to be qualified as that expert. And we would ask this board just to consider him as an expert in urban planning as it relates to his duties and responsibilities for the city of Asheville and the interpretation of his ordinances.
Mr. Sneed, I'm looking back at you.
Okay. An expert is a person with knowledge that the guy on the street doesn't have, but that through his training and education and experience knows about a subject matter, enough more about a subject matter to be able to help a board like yours understand matters within his field. We want to ask him about medicine. He doesn't have that degree, but this board can find that as an urban planner, he has testified enough as to his qualifications to accept him as an expert. I will note, I'm not sure where Mr. Golden is going with this, but he's also testifying his position with the city, and you have to keep that in mind as he makes his statements. I would add, too, we're having discussions up here about whether or not he makes interpretations of law. UDO is law, that's his job. But they are correct. There are legal opinions he cannot give, but interpretations of the law he does every day. Zoning ordinance and the statutes that apply.
From a procedural standpoint, do we need to make a motion and vote whether or not
Well,
he is an expert?
Expert witness.
You do act as a board, so I would probably ask the board if for a vote on whether or not to accept him as an expert.
So what is the criteria to accept him as an expert? Is there a particular criteria?
That you find that by means of his education, training, and experience, he can provide information to you greater than your own knowledge as to particular subject matter. And again, expert comes with a heavier name than the qualifications require on it. I'm a little more generous about expert because the definition is training, experience, and education. Give him knowledge that can add to this discussion and help you make a decision.
The term expert is
It's just that.
just a name in itself.
It's a
It
person.
doesn't give any credence to.
Well, he's able to give an opinion, an expert can give opinion testimony that a layperson cannot. I can give you opinion testimony as to the law. Your architect can give you opinion testimony as to how you should structure your house. So it is opinion testimony. The guy on the street, you may not want him telling you how to build your house. Your architect you might trust because he's an expert. You're just looking for somebody with additional knowledge, experience, and education who can add to your understanding of the question.
And I'm sorry, board members and Mr. Sneed, unless you are willing to talk as loud as Brian, please get very close to the microphones. It's very sensitive. They have some noise canceling. Please just get in the habit for those watching at home and for the minutes to get as close as possible.
Okay, so if I'm hearing you correctly, this is just a question that's posed to the board and with a simple aye or nay. Is that correct, Mr. Sneed?
Does this board find, how many on this board find that he should be treated as an expert?
Does this board qualify Chris Collins, Assistant Director of Planning and Urban Design Department of the City of Asheville, as an expert witness? All those in support of this say aye. Aye. Anyone opposed? Okay, great. I can't imagine we not being.
If I can just get, and I'm going to speak for a second, if we can get ahead, if this is going to be happening every time he asks us a question, can we just go ahead and vote on it, and that satisfies all above requirements, and we don't have to talk to you about it? I mean,
I don't sit with this board very often. Some boards delegate to their chairman the ability to make certain rulings. I don't know that you have that kind of designation as to experts, so not knowing, I'm recommending you just do a vote to accept him as an expert in urban planning.
Thank you for granting me that authority. Appreciate that, Michael.
we got to move it along, guys. Dinner's coming.
Yeah, and I did not, and I apologize, I didn't give a forecast of how long this will take. I'm hopeful it won't take very long.
Thank you so much. And as just an abundance of caution, I want to make sure that we're doing this procedurally properly. So that's why I'm referring to our attorney, Mr. Sneed. So go ahead, Mr. Cole.
Thank you. Now, Mr. Collins, thank you. You've been qualified, and I think that will give you the opportunity to talk to this board about the zoning determinations that you made. Now, those facts are not in evidence yet, but did there come a time, as it relates to 17 North Market Street, that you were requested to make a zoning determination?
Yes.
And what was that, the zoning determination, the result of? Do you remember?
City staff had issued numerous notices of violation for short-term rental activity in the condominiums that are subject to today's discussion.
And on or about February 6th, did you or someone from the city, this is part of the record that's been provided, on or about February 6th, and I've got it marked up there, did you or someone on behalf of the city receive a letter from Mr. Swords outlining his client's position as it relates to their ability to short-term rent?
Yes.
And does this, and I'll just scroll through it, does this look like the letter that was submitted to the city requesting a zoning determination?
It does look like it was submitted to the city. I do see it was submitted to Brad Branham and Eric Edgerton. I honestly can't attest to having read this exact document.
Okay. So then that would, if you can't attest to having read this exact document, why did the responsibility fall to you to issue a zoning determination letter?
That is traditionally something we've done in the city with folks who carry a, who carry a leadership position within the Planning and Urban Design Department and are considered to be well-versed and trusted with the interpretation of the code.
And so I guess without having testified, or with testifying that you haven't read this letter fully, what information were you given and by whom to make a zoning determination?
There were numerous conversations that occurred about this Some of it was direct information, some of it was information that occurred from interactions with folks from the firm featured on that letter and our city attorney staff. And we collected a lot of information. I had firsthand conversations as well. Wasn't necessarily just information given, it was information researched and pulled from our own permitting and development records as well.
Yeah, and so if you could, and there was a little bit of you issued two zoning determinations letters, one on February 17th and then a revised one on February 21st. Do you recall, and I'll put up the February 17th letter that you received right here, February 17th. Do you recall what the difference was between that one and this one shown here on February 21st?
You know. Yeah, please. We've had a few things happen since then, and there are a lot of details here.
So there was this letter when you initially wrote it on February 17th. It's up here. You were talking about identifying right here the 20 guest rooms. In the other letter, I believe you, there was, you go over here, you were talking about right here. Staff did not take advantage of the opportunity to find the 20 guest rooms. In the other letter, do you recall that you excluded the reference to the 20s? Right, so, right, and the part of this approval, you just got the guest rooms that were received as lodging guest rooms. You took away the 20. My question is, why was that important?
We had had a conversation following up on the first draft that this whole entire development was, try and make this a long story short as well, this entire development was less than 20 units. We had had several around the same time as this that were more than 20 units. And it was necessary to identify the 20 because that was the entitled amount of rooms that were eligible to be used because of zoning for lodging, right? Now, obviously, when the entire development is less than 20, it's not necessary to identify the 20 units if they're looking to use each unit as a lodging use.
Thank you, thank you, I appreciate that response. So I want to kind of walk through a little bit of this letter with you. Now, you're familiar with 17 North Market Street and the zoning district in which it's located in the city of Asheville.
Yes.
And do you recall what zoning district it is in?
That's Central Business District, CBD.
And I think at your opening staff presentation, you indicated that a development permit application for the development of 17 North Market Street was submitted to the city of Asheville on and around December 14, 2017. Is that correct?
Yes.
So tell the board a little bit about what regulations, as it related to, we'll call it short-term vacation rentals, what regulations related to short-term vacation rentals in the Central Business District existed at the time, December 14, 2017, that the application was submitted?
At the time in December, bear with me one second. I have a little timeline here because there's a lot going on. Yep.
If you need something for me to show, please let me know. I'm happy to.
So I believe at the time, we were at the point where lodging was allowed within the CBD at 20 guest rooms or fewer.
And when you talk about lodging, I think in your letter, you indicated right there that at this time, the city's unified development ordinance did not
Correct, yep.
And how did it treat lodging? Or was it a use category? What was so important about lodging? You've got it in quotes here.
I would have listed this in quotes to identify a use that would have appeared under our land use table, permitted land use table, which is the portion of the zoning that corresponds to the districts and lays out what can be done in each district.
And so do you recall back in 2017 at the time the application was submitted, what was a permitted use in lodging?
What was a permitted use in lodging? We didn't have it broken down or defined as we do now. Right now, we have things such as hotels, extended stay, large, small, short-term vacation rentals. It was really a broader category at the time.
Do you recall, and you mentioned that in your letter, you indicated that on February 14, 2017, the city of Asheville adopted ordinance 4560, which among other things allowed lodging facilities. Do you remember that? And so is that still true to the best of your recollection, that lodging facilities with fewer than 20 guest rooms could be approved in the CUD?
One moment, please. That is, yes.
And if I can, this was part of the ordinance that was submitted as part of the packet. If I can ask you to look up there on the screen, is that the ordinance which we're referencing, 4560?
4560 that predated this application. Hold on. Yes, after the adoption of 4560, yes.
And this is the provision that we're talking about here under lodging that says, under the lodging heading, lodging facilities, 12 guest rooms or less are denoted by P in central business district. Is that correct?
Correct.
And so did the city have anything as it relates to short-term rentals and how it treated those short-term rentals?
At that time, I don't believe so. I don't have that version in front of me, but
And did the city consider short-term rentals as a lodging or a residential use?
from a zoning perspective, I'm going to make that distinction because I'm not citing North Carolina building code here, which might approach it differently. Short-term rentals would have been they weren't defined in the ordinance as a lodging use. I can answer it that way.
And do you recall how the city of Asheville how they treated short-term rentals, how city staff, maybe even under you, presented it, how short-term rentals were treated or identified in UDO at that time, using 4560?
I'm not sure I fully understand the question.
So if, what's his, Todd,
Oklahoma, you're speaking
Oklahoma.
of previous planning director, yes.
yeah, previous planning director, and how would, so again, my question is, you as the urban planner for the city of Asheville, working here since 2017, how do you recall the city treating short-term rentals, and how were they presenting it to city council, planning staff, as to what was required in order to have a short-term rental?
Madam Chair, we'd like to object to that question to the extent that it seeks this witness to say what the previous planning director did.
Okay, not to prolong this meeting, Mr. Zane.
Unless the witness has direct knowledge of what the previous planning director, how he identified short-term rentals, he really can't answer that question. I think that's the objection. He's having to read the mind of the prior planning director.
Okay, that makes sense
That
to
makes no
me.
sense at all, huh?
He cannot interpret someone else's thought.
Only if, in some fashion, the planning director put this out to staff, that this is what a short-term rental is, then he's being asked to answer, to give an opinion as to what the prior directors, how he would have described it.
So he can only speculate.
Well, we don't know. I guess I think there's a beginning question for him, is how, does he know what the prior planning director, how he described it, and how do you know that? If he doesn't know that specifically, then either he can't answer it or their objection is valid, either one.
So I guess the question to Mr. Collins would be, do you have direct information or knowledge about former planning director, I will butcher his last name, information related to this latest question?
I do not have direct factual knowledge about how Mr. Okolachaney approached this situation.
And you're aware that there, in this period of time from 2017 to early 2018, there were a lot of debates, I shouldn't say debates, there were a lot of conversations had between planning staff, planning and economic development committee, and city council, and zoning administrators about short-term rentals.
I am generally aware of that, yes.
And I've got a staff report that was to the Planning and Economic Development Committee from the prior planning director, prepared by Shannon, talking about this exact issue. Are you familiar with this? I'll just highlight it. You familiar with this document?
Just generally, I certainly haven't researched or prepared based on this document.
And are you aware that Mr. Cole talked about the conversion of an existing residential dwelling unit into an STR located in a zone that allows lodge typically requires a change of use. Right? See that?
Yes.
And so it was in the city's position at that time, did you know, that short-term rentals were considered a form of lodging facility?
I don't believe the presence of that in a staff-produced document equates to a UDO provision, so it is stated there, but it's not like a rule of law I could fall back on to make a decision just because someone said it in a staff report.
How in 2017 did you understand that the city treated short-term rentals? As a lodging facility or as a residential?
I wish I could give you an easy answer because we administer it from multiple code provisions and it applies differently depending on what you're looking at. We didn't have anything written in our ordinance that considered it a lodging use. Now, we did have certain districts where it was not a permitted use and enforcement action was often taken on this.
So, all right, so we've talked a little bit about the zoning determinations that you made, we'll pull it back up, that talked about ordinance 4560, which was the ordinance in effect at the time that the application was made. Do you recall, did you look at, in making your zoning determination, did you look at that original application?
At the original application for this development?
Yeah.
Yes, yes. That's fine.
The original application for this development.
Yes.
And do you recall how they submitted it? Did they submit it as a residential use or a lodging facilities use?
Actually have it in front of me here, I believe, so. They did not spell out a use for the application. Do you have I'm looking at the application now, so.
I'm just looking at change of use, no provisions, kind of, or previous
Previous use.
condominiums.
Right, that's what I see as well, yes.
And this is the application that we're talking about, this TRC site application as it relates to development of 17 North Market Street.
That was a level 2 development application, so that is for the site plan approval, covering zoning, any stormwater or land disturbance or grading as well.
And now that we're talking about that, thank you, it wasn't going to be my next question, but we'll go there. You had talked about zoning, building, stormwater, grading permits. This was a development application that had to go through multiple permitting steps. So it had to get zoning permit and TRC approval and site plan review approval, maybe grading, stormwater, sidewalk approval, multi-development permit approval throughout the process.
Correct. In this case, thinking back to this one, this was only a zoning permit because it is a building-to-building development downtown with no additional earth disturbance or impervious surface beyond what's already there. So it was a zoning-only permit in this case.
And when, do you recall when that zoning permit was issued and part of the record that's been submitted?
Yeah. Thanks. Yeah, go ahead. It was issued on May 25th, 2018.
And the very first thing it talks about is a zoning permit for 15 residential condos. Is that correct? And at that time, because this development application had been submitted when ordinance 4560 was in place, this could have been a zoning permit for a lodging facility to designate less than 20 lodging facilities. Could have been?
Give me a second to think about the timeline. That ability would have been there, yes.
And at any time from the submission of the application through the zoning permit and all the other, I guess, development permit approval, site plan approval, was there any effort made by anybody to designate the use of 17 North Market Street as a lodging facility?
I didn't find anything at the time in the record, but a lot of that conversation goes between staff that are no longer here and applicants that I was not working directly with at the time. We do have some developments that were issued in this fashion and did come back and identify that 20 or less units that would be used in this way. The reason we asked those developments to do that is to verify that that 20 threshold was being observed.
And so I'm pulling back up here, February 21st, 2025, zoning determination letter. And right here in the middle, it talks about multiple projects that were under development chose to identify guest rooms never received any time. You remember that? Yep. And you looked at all of those permits, correct?
Yes, I did.
And the way that it would normally fall into the city's jurisdiction is that potentially somebody would get a notice of violation, they would submit a change of use permit from residential to lodging facilities, and then you would issue them a new lodging facility permit.
What's being referenced in this letter as other multiple condo unit developments were a different situation. They were still under development. There was no notice of violation involved. It was more of a proactive effort to say, hey, we heard about this new ordinance. Can we take advantage of it? And they proceeded to submit a list of guest rooms that would be used as lodging.
And this applicant that we just talked about, the TRC application that we looked at, did they ever come to you or city staff that you know of indicating that they wanted to change from 15 residential condos to maybe 15 lodging facilities?
At that time, not that I know of.
And so as it kept moving along in the process, on January 9th, 2018, City Council adopted a new ordinance, which in essence prohibited short-term rentals in the central business district.
Correct, yeah.
And at that time, after that new ordinance was adopted, Did anybody from the development team of 17 North Market Street approach you asking how they can designate those units as lodging facilities to allow short-term rentals?
Not me directly, but I will say we do have quite a few staff members, but I can't attest to that happening.
On the second page of your opinion letter, so the first page we walked through, those are all the facts as you recall it to be at the time that this development application was proceeding through. On the second page of your letter, you say North Carolina General Statute 160D1A states that the permit applicant may choose a version of each of the local land development regulations applicable to the project. You remember writing that in your letter?
Yes.
And just for clarification, at the time that you're going back to the development submittal of 2017, 160D wasn't actually codified yet. It would have been 168 or 385. But you went back and you looked at one that 385 was basically the same.
Right.
And there's a provision in 160D, and we can go to 385, but if we just go to 160D that you were quoting from subparagraph E, and we'll highlight it right here. So this, this is the section that you were referencing, that you use, the law that you use to make your zoning determination, is that correct?
That is correct.
Right, so on that second line down, I'm going to read it to you, tell me if it's correct. That the development permit applicant may choose the version of each of the local land development regulations applicable to the project upon submittal of the application for the initial development permit. Is that what you're talking about?
That is, yes.
And did they, at the time of their initial development permit, did they make any change to the residential use?
Excuse me. It wasn't indicated on the initial TRC application as we illustrated.
And was it indicated on any other development permit application, like zoning application, or a stormwater, grading, sidewalk permits?
They did not have, this application did not need to carry any stormwater grading permits, so those don't exist. I don't have in front of me now all the site plans, which may contain notes on the use, but that will be something to evaluate.
And then the next section I want you to read again, it says, this subsection is applicable only for those subsequent development permit applications filed within 18 months of the date following the approval of the initial permit. My question is, why did you leave that out of your consideration when you were looking up 160D108 for this determination?
For this determination, it was found that after conversations with the applicant and reviewing of application materials, that the intent was to allow this as it was allowed by the zoning at the time the application was done. And it was found not necessary to identify 20 or less guest rooms that were able to be used because the entire development was less. Again, the concept being some of these others where we had, let me see, 70 units in one of these, it was necessary to say which 20 or fewer of those 70 units were going to receive the entitlement or the allowance to operate as short-term rentals. Or another case where there were, that's the same one. Well, let's just use that example. I thought I had two different ones here. But, so we found that that was the only reason we asked for plans to be amended for those projects at that time, was to identify the rooms that were going to be used. And we were presented with the concept that this was not 20 units. If they wanted to use the full entitlement, that right to 20 units covered the entire development. So that step that was taken to amend these site plans to show which units were done wouldn't have been asked of these folks And it wasn't even a process that we put out there for people. It was something people came to us on to do to kind of get that information in the books with their developments. So,
And so the applicant, back in 2017, identified it as residential. Back in early 2025, Allenstone and Kilbourne Law Firm PLLC submitted to you information to change the use from residential to lodging. Is that a clear understanding so far of what happened?
correct, yeah.
And then I think you just previously testified that you looked at the intent of the original application, or you investigated the intent of the original development. Is that correct?
Yes.
And what did you do when you investigated that intent?
We found evidence of continuous use of units as short-term rental units within the development, and we had conversations with the folks who originally developed the property. Those two things together showed an intent and an action to use the units within the development as short-term rentals.
And when you were talking about that you were shown continuous use, who showed that to you and what information did they provide?
That was evident to us as the city through a history of open and closed in various states of zoning enforcement cases and complaints that have been submitted to the city about the use of the property as short-term rentals, as well as some investigation through a third-party service that we use to track the use of units as short-term rentals.
And so when you're looking at that, and that's pertinent, germane information, did you look at when the certificate of occupancy was first issued and when the city then first filed a notice of violation?
I don't recall if we pulled that specifically into it.
Do you have an understanding as to when the certificate of occupancy was issued?
I couldn't give you that date right now, but we could look it up.
And do you recall when the first notices of violation were issued?
The first that we have referenced in the record were from July 3rd, 2024, because those were appealed, but there was a pretty long trail of enforcement activity preceding that in our system.
And then Mr. Swartz, in his letter to you, said, number 8, construction began in October of 2018 and continued uninterrupted, although it was slowed by the pandemic. COs were issued on and around May 21st, 2021. You wouldn't have any reason to disagree with that, would you?
No.
And so from 2021 to July 2024, how can you, with any type of certainty, because that's when your first notice of violation was issued, how can you with any kind of certainty during those three years indicate that they were continuously used for the short-term rental?
Well, as I stated before, we reviewed enforcement records that may not have resulted in notice of violations or citations, and we did see continuous evidence of the use of those units, of some of the units, as short-term rentals. And we did look at our system that we use for city, or that the city uses for tracking short-term rental activity from an enforcement perspective.
And is any of that information part of the record that's been prepared for this board?
I don't believe so at this time, no.
You also indicated in your letter when you made your determination that 17 North Market was made with the original intent. Talk a little bit about it. I want to come back to that. On that original intent, you know it's a condominium subject to restrictive covenants. You understand restrictive covenants don't govern over the city's UDO, but can be allowed. But did you look at it in the sense that it could have said all of these units had to be owner occupied? Did you look at the restrictive covenants to see if there was any limitation on how it could be used in order to determine the original intent?
Excuse me. Well, as you stated, restrictive covenants do not govern over the UDO and zoning, and restrictive covenants are not an area where I am authorized to exercise any power or enforcement, so we do not review those on any development case that we get. So they were not reviewed in this case either.
But wouldn't it have been germane to determine the original intent of what the development was for? Just look at it briefly, see if there were any restrictions on these.
In my eyes, I do not bring those into any work I do with the UDO. So for me, and without having seen the document, I can't say whether it would be germane or not.
So, and we've gone over number 2, well, I like this right here. Number 2, the units noted above. Number 3, the owners of these units had a good faith belief that short-term rental use was allowed as residential rather than lodging use. Which owners did you talk to specifically to determine what their belief was?
We were engaged with the original development team and those represented by the firm that had appealed, acted to appeal these original notice of violation.
And did you go back in and look to see if there were any public records, email communications, or anything from any of the residents at 17 North Market Street that talked about short-term rentals to get an idea of what their belief was, other than development?
I was aware of some emails that had gone back and forth with the city's enforcement staff around these notices of violation and complaints. But we were looking for intent at the time that this application was made, rather than these emails that were coming through in, I don't know what year, 2023. We were looking at the intent of the original application rather than emails that had come to us that I may have been aware of in 2023-ish, 2022, whenever that year was. Not having them in front of me, just take those dates as a ballpark.
Yeah, but the letter says that you talked to the owners of these units, had a good faith belief. So it's not the owners that purchased the units, but you're saying the original development team?
Well, I think in this case, I'm referencing the owners that were appealing the notices of violation that had been issued to them.
Sure, one of those owners was Mr. Patel. Remember him?
I haven't personally encountered Mr. Patel.
And do you remember, did you look at his emails that he had sent to the permanent facilitator and Joel Park in the Development Services Department?
I don't think I had those on my, I have not viewed those.
And in your letter, you say, making the following zoning determination, the city materially relying on the information you have supplied. Was there, again, I want to ask, who was it that supplied information, and what was it other than verbal communication in these person-to-person meetings?
We did have some written communication. The letter, if you scroll back, you'll see was addressed to Mr. Swords, and they had supplied verbal information as well as written information, I believe, in a letter that you had up earlier on the screen. And there have been numerous emails as well.
Are any of those in the packet of the record that the board is considering so that they have a full scope of what your investigation and findings were?
I don't believe any of the emails got into the record here, so.
And this is the letter that you're talking about, some of the information that was.
Correct.
Did you, Mr. Swords, indicated a 8, I think, starting here at the bottom, starting here at the bottom, cited to 8 notices of violations that were cured simply by submitting a lodging application. Did you look at all 8 of those? I guess it was 5.
Where is this that we're looking at here in the letter?
Yeah, this is the letter.
I did not look at each because that was a common practice. We've dealt with hundreds of violations related to short-term rentals over the years here in the city. And there are one of about 3 to 4 ways people cure those, and that's pretty common.
And, I mean, would it have been important or germane to your determination of
I didn't see a reason to review each application because those are, again, commonly cured in that way. So it's not like to be in disbelief that, wow, somebody cured a short-term rental with a change of use application. There's not a lot of unique situations involved in those.
You ultimately say, as it was arguably unclear as to whether the intended short-term rental use of the property should have been permitted as a residential or lodging use, it was determined that they may complete the change of use permit application. So they'll have to submit, they, the applicant, will have to submit a change of use zoning application. That comes about 8 years after their initial permit was submitted after their initial application.
Is that a question?
Yes.
Okay.
Is it about 8 years or so, maybe 7 years?
Roughly.
Objection. I don't believe that's the question that was answered. I would ask the council repeat it in its entirety or ask the question again.
I will ask that question again. So my question is, will they have to get a change of use permit to facilitate the change from residential to lodging facilities? That's the
Will they, certainly, and I think the letter actually lays that out, that would need to go through that process. And it has been done. The applicant has requested and been approved for that change of use at this point. Giving them that leeway because when the change of use was done, it was never broadcasted to anyone that you need to identify units or anything like that. We just had a couple that came to us and did that.
And the original, we looked at it, we can put it up if we need to, the original zoning permit was issued back in 2018. And so now, 7 years later, is it the city's position that you can allow an applicant, 7 years later, to modify 15 residential condo zoning permit by changing use to 15 lodging facilities?
No, that's not the city's position. The city's position is that they applied in a time frame when this was an entitled use for the property, and a situation changed whereby a select few developments approached us to identify some rooms that were needed. Staff being aware of what was out there and what was being developed, didn't need to create a program or an application for this, but it was an easy change for anybody to go in and do that needed to identify 20 guest rooms or less. To make that change, in this case, the argument that was presented to us is there are fewer than 20 guest rooms here. We did not need to identify which units. It wasn't allowed use when this application came in.
And so, just to finish up real quick here, does the applicant have to apply for a change of use permit in order to short-term rent?
Do they have to? By nature of it being allowed use in the zoning district, I don't know. They may still have the right to do it, even if they don't apply for a change of use because it wasn't allowed use within that time. Did we ask them to do that? Yes.
And so I'm just plugging out your section 7.5-2 zoning permits, you familiar with that?
Yes.
And I will highlight this and you let me know if you correctly. In addition to new uses, zoning permits should also be required for expansion of existing units as well for changes of use. Is that correct? Did I read it correctly?
Yes, you read it correctly.
And is it the city's position that there is a change of use from residential to short-term rental?
Based on the ordinance that was in effect back at that time, I mean 2017 of December, it was not clear in the UDO that there was a change of use that would occur between a residential condo and a short-term rental use. Right.
fine,
Yeah,
gentlemen.
let me wait and see. Have to get a more comfortable chair then.
You're welcome to use
Yeah, I think it's the same, yeah.
You can stand.
This will work better.
When you answer questions, can you get closer to the microphone for us? Just
Yeah, I can certainly try. There's no leg hole here, so it
Oh, I got it.
restricts how close, but
Not
we'll give it a
making it
shot.
easy on you.
Mounted inside of the,
This guy?
yeah.
It moves a little,
It
yeah,
moves a little.
yeah.
You can also open the cabinet and create a little bit of a knee hole.
True. I could climb on in there, yep.
Okay, do I need to call up the next person, Mr. Sneed?
They have a right to cross-examine, and the city may want to cross-examine.
The city is going to have a very, very brief cross-examination. And then the individuals that you held to have standing will have the opportunity for cross-examination.
Okay, so do I need to invite you up or to ask questions?
No, I'll just ask from here.
Okay, great.
Mr. Collins, you and Mr. Golden discussed some other buildings that had applied around the same time as this subject building to be used for lodging. Can you just explain again what the difference between those buildings and this one was?
Sure. I believe we looked at, well, we were familiar with a development of 55 South Market Street, which was a level 2 condominium development. You may know it now, across the street from Triangle Park. And then 45 Ashland, which is another larger residential condominium development. Both of those were approved in a similar time frame. I think I just have a copy of one in here right now. But the main difference there is that they had at least 70 units each, I believe, unless I'm getting it mixed up. Whereas I've heard different numbers tonight, and certainly somebody here knows how many condos are at our 17 North Market, but roughly 13 or to 12 condos are there. So there's a pretty big difference in the size and scale and number of units in those developments.
It was definitely fewer than 20 units,
Yes,
correct?
definitely.
So it didn't need to define which units were going to be used for lodging because, as the ordinance that you looked at the time for level 2 development said, up to 20 could be used for lodging, correct?
That's correct.
You and Mr. Golden also talked about ordinance 4560, which is item 2 in the record, and the record was supplied to the board. Do you have the digital folder pulled up in front of you? It's called Record of Administrative Decision. I just want to make sure. That's what Mr. Golden has kind of been referring to this during this time, in addition to other documents. It's just ordinance 4560, item 2 in the record, page 17. Yeah. So it's pulled up on the screen now, so if you haven't had time to pull up the folder, it's right there. So this states that at the time this ordinance was adopted, which as you discussed was February of 2017, lodging was added to the permitted use table for the CBD district, correct?
Correct.
Which is the district that this property is in, correct?
Yes.
So lodging was a use allowed as of right, correct?
Correct.
So, in your opinion, did they need to submit any change of use permit?
In my opinion, we asked, as stated, larger developments to submit. There was a big focus at the time on the 20 guest room provision, and that being the entitlement or the allowance for development. So there was a large focus on, hey, you're 55 South Market, or you're 45 Ashland, you're a big development. Great, you want a short-term rent? We need to know which units you're doing it, so we know where that entitlement lies. It wasn't really a change of use with those two development applications. It was a specification of how they were utilizing that zoning allowance, so that going forward, we would know, not we, city staff, city enforcement staff would know what units could be doing it and what couldn't for purposes of maintaining that allowance.
So it's more of an administrative kind of method rather than a right to use land for a land use, correct?
Correct. It was an amendment to their site plan simply because any change to an approved plan is an amendment to a site plan.
And being a level 2 development with fewer than 20 total units, lodging was a permitted use at the time of the application, correct?
Lodging, 20 guest rooms or less, correct.
And you wouldn't ever look at private restrictions on uses of land like restrictive covenants when making a zoning determination in your role in the planning department, would you?
I think that's one of the first things we learn in public sector urban planning is to pretend like those don't exist because they don't interact with our zoning regulations and we have no ability to interpret or, what's the word I'm looking for, enforce those in any way. So we stay out of that realm with every action we take.
I don't have any further cross-examination. Thank you.
Nothing from us.
Nothing from you guys?
You good?
So, Mr. Sneed, where do we go now?
We've just got 2 more witnesses. I think
Keeps
they'll be
calling
short.
witnesses, yeah.
Thank you. Okay, Mr. Golden, we've had one appeal, one appeal in my 4+ years here, so it's not very often we get to do this procedure.
And I apologize for the length of our presentation, and I appreciate the opposing sides, cross-examination. Ms. Osborne's going to call our next.
At this point, we would call Mr. Gerald Green. And I will try to be a little bit more brief and round on this one and talk loud enough to where I don't need a microphone, but Sam let me know if you can at any point. All right, Mr. Green, could you state the name of your board one more time?
Gerald Green.
And you are a certified planner, is that right?
That's correct. I received my certification in 1990 and have continued with the education to maintain that.
So could you walk me through your education in a little bit more detail?
Okay, I have a bachelor's degree from Virginia Tech, a master's in planning from University of Tennessee. I have a certification in local government administration from Chapel Hill School of Government, for which I received the Outstanding Student Award.
And how long have you been working in planning?
And December will be 43 years since I received my master's degree and came to work for local government.
Okay. I'm going to hand you a document here. Is that your resume?
Yes, it is.
And does it accurately reflect your work history and areas of expertise?
Yes.
Members of the board, I ask that Mr. Green's resume be admitted as an appellant exhibit 1, and I have copies to share with Ms. Scotty, if I may.
Thank you, and I feel confident that this board will approve Mr. Green as an expert witness.
A few I left off, actually.
All right, so in your resume, you have set forth a robust employment history. Can you walk me through some of your employment history?
I served as planning director for the city of Brevard in Jackson County. I worked for the city of Asheville for 14 years. I served as executive director of Knoxville, Knox County Planning, and for about 10 years I had founded, grew, and managed a local small planning and design firm, award-winning planning and design firm.
Can you tell me a little bit more about what you did for the city of Asheville specifically?
I started as senior planner in charge of current planning, similar to Chris, and then became chief planner and did pretty much everything. And those included development review, preparation of community and small area plans, and the UDO. I was project manager and lead author for the UDO.
All right, and you've also listed a lot of different projects and experiences there. Could you tell the board about some of the specific projects that you've worked on?
Yeah, Transylvania County Pre-Development Ordinance, which was used as a model by the jurisdictions to assure before the counties had subdivision regulation compliance with the local regulations. The conditional use zoning for the city of Asheville, which I thought was good then, and now it's a pain and bigger pain than anyone could imagine. The UDO, which brought several new concepts to the city. Bicycle parking, sidewalks, development, and compatible with surrounding neighborhoods, and should have been updated 15 years ago. And let's see, the Knoxville, Knox County plan development approval process, which took plan development from a quasi-judicial to a legislative process, offering incentives for developers and doing away with the quasi-judicial hearing in favor of a legislative hearing. The Sevier County strategic housing plan, which allowed for development of housing that would serve the workers in the county. And finally, the City of Knoxville zoning ordinance, comprehensive rewrite of the city zoning ordinance, for which I served as project manager. I served as project manager again on the UDO. My firm prepared the first zoning ordinance for the village of Cashiers. We also did other development ordinances, including the land development ordinance for the city of Jamestown, North Carolina, which won an NCAPA planning award. It was one of the first hybrid ordinances, which incorporated both form districts and standard use districts. The city of Knoxville zoning ordinance, updates to community zoning ordinances ranging from Biltmore Forest to Rutherfordton to trying to remember some of those, broad range of ordinance updates. The first zoning ordinance for the Cullowhee community. I think that's enough.
Okay, yeah. And have you been qualified as an expert before a board of adjustment?
Yes, most recently in Madison County, town of Woodfin, Cashiers, and several others going back further in the past.
All right, thank you for that history there. Members of the board, I would like to qualify Gerald Brin as an expert in land use planning and land development regulations.
Madam Chair, we would have an objection, but I will defer to the city attorney if she would like to speak first.
I don't have any objection.
Right, so there is no question that Mr. Green appears to be a seasoned planner, and in the proper setting could be an expert. However, this is an evidentiary hearing, not an opinion hearing. Mr. Collins had knowledge of the facts and the letter that was at issue here today, personal knowledge. He drafted the letter. He was involved in it. Mr. Green does not. Mr. Green can only make legal arguments as to why the city got it wrong. But that is Mr. Golden's job, and Mr. Golden is here to do that. So there doesn't need to be someone giving their legal opinion. The board should not hear his testimony. All that he can do is testify as to matters of law. and that's improper. Expert testimony is only admissible if an expert's technical expertise will help this board understand a fact at issue. I think that is how your attorney put it, and he will let me know if I misquote it. But I do not think that the board should hear this testimony.
Mr. Sneed, do you have guidance for our board?
I wish I did. It's a good argument, but at the same time, you're a board, you're not a planning board, you're not deeply involved in planning. You're going to hear arguments about how the ordinance should have been looked at, and if you accept him as an expert, only experts can give opinion testimony. Where else are you going to get some sort of information in addition to just what was testified to that will help you understand how you not only do get to interpret, you have to make a decision today. So it's your decision whether or not to accept him as an expert, and then, of course, you may anticipate some objections question by question, but if you think he has the qualifications to answer some questions that will help you understand what you're trying to decide a little bit better, I think you can do that.
Madam Chair, if I may, the issue here is how can he help you understand the decision that Chris made? I'm sorry, Mr. Collins made. Mr. Collins has already testified to that. He can't have an opinion as to what is in Mr. Collins' head. All he can do is make legal arguments as to why he thinks Mr. Collins got it wrong. But again, that is the job of Mr. Gould, and he will be telling the board why his legal arguments and his legal conclusions as to why he believes that the decision is incorrect. But it's not proper to have an expert in here giving that. We aren't talking about, something that has been scientifically researched here. This is just his opinion that is going to be solely based on legal conclusions. And I worry that it could be improper evidence before this board.
And Madam Chair, I hate to interrupt, and I apologize. Rule of Evidence 702 does talk about an individual with specialized knowledge whose training and experience that can offer some advice to help the trier of fact find a specific fact. You haven't heard his testimony yet, and Mr. Freeman is saying that he's just going to make legal arguments. Experts can look at documents before they testify, can form opinions on what they should have done, what they could have done, what would have better been done to come to a conclusion. That's not a legal argument. That is the purview of an expert to say, I've looked at the record, I've analyzed the record from my experience, and he can give his opinion. He outlaid all of his opinion as to his expert testimony. If what Mr. Freeman is saying is correct, we would never have the need for expert opinions. Why? Because, the one who wrote the book or the one who did the investigation told you what they found. Well, that's not always the case, because what that investigation may have revealed may be different to Mr. Collins, as it may be different to Mr. Green, as it could be different to their expert planner. So it's not the fact that he's going to make legal arguments. You haven't heard any of those yet. Rule of Evidence 702, can he assist you in coming to your conclusion? You all under 160D 405 step into the shoes of the zoning administrator. You heard his side of the story. There may be another side of the story that you need to hear. We are bringing Mr. Green here to offer that other side of the story. And it is absolutely permissible to hear that evidence. You can give it a lot of credibility, or you can give it a lot of weight, or you can give it no weight. You haven't heard the testimony yet. His training and experience offers the ability to enlighten you on a finding of fact. He's not going to argue the ultimate conclusion. Mr. Freeman's right. That's our job, to argue the ultimate decision or the ultimate conclusion to try to persuade you. But his factual investigation, reasonably relied upon by experts, may come to a different conclusion. And we would just ask this board to hear that conclusion.
Board, do we have any discussion on this?
Yeah, Madam Chair. Is there a way that we can actually,
Can you have the discussion in the microphone?
Oh, I'm sorry. Madam Chair, is there a way that we can perhaps have a discussion about it? And as I recall, sometime in the past, Mr. Sternberg, we had something similar in that we were evaluating an expert opinion versus someone just having an opinion, and maybe not using that as a legal argument. Can we exclude that?
That is a whole different ballgame. I think that was in reference to public comment versus standing.
Yes.
Yeah, that was for a variance. I would ask that you discard that entirely.
Okay.
And I will be very clear in that I am not an attorney. I am just here as a very simple, lowly board liaison. Having written the member's manual, working with legal now to rewrite this is a thing in your purview. You will ultimately be voting to see if this is an expert that will help you clarify. If you want to have a discussion, if this helps you clarify, have the discussion to see if Mr. Green would help you clarify. And that's your call. That's why we give you the free bus pass.
Thank you. And that's sort of where I was going. Some way, Madam Chair, that we can have a discussion about it and then perhaps maybe exclude the legal action portion of it? I don't know.
Well,
Just
we
throwing it
don't
out
know the
there.
questions that are going to be asked, so we don't know what the answers from Mr. Green are going to be. So they'll either be objected, or he'll be asked questions under cross-examination, or we can decide not to listen to his testimony at all. Does anyone have any strong opinion about this?
Well, I understand what they're saying, and in some ways I agree, but the city doesn't care if he testifies, and they're one of those people in this, so given that, I would say that he should let him testify.
And our attorney, Mr. Sneed, has said that it is worth listening. I don't want to put words in your mouth, but you did say something to that effect. So I'm inclined to listen to the questions and answers that are being presented. Any other questions, concerns? You're good? You're good?
I would personally like to hear what he has to say, because I think it's important that we have some sort of understanding of and direction, because we will be making a decision.
Great. Okay. In that case, you may continue.
Madam Chair, I'm so sorry. May we just preserve for the record our objection not only to his testifying as in the manner that we talked about, but also just generally his qualifications as an expert. And we just want that preserved for the record.
You just did it. You just did it.
Thank you.
Like, okay.
Okay, we're going to move forward then. Mr. Green, are you familiar with this administrative appeal?
Yes, I am.
All right, how so?
I reviewed the appeal, the zoning determination letter, the state statutes, the local ordinance, reviewed the permit application, the issued permit. I believe that sums it up.
Okay, so is it fair to say that you have an understanding of what has occurred and when it occurred in this appeal?
In my opinion, yes.
Okay. So when you are interpreting a development standard in an ordinance, what are the steps in your analysis?
I have some questions that I ask. Those questions are, has it been considered before? How is it addressed in local ordinances and statutes? Would it set a precedent? And finally, is it so overwhelming and pervasive that it should result in an amendment to the ordinance?
And are those questions that are asked and reasonably relied upon by individuals in your field when interpreting these development ordinances?
I believe so. The last time they were discussed with a local government was with Krista Kukuro, the city attorney for the city of Knoxville, when we were developing the ordinance. And Krista is now on the faculty at School of Government, I believe.
And so based on your review of the documents for this matter, did you prepare a report?
Yes, I did.
All right, and I'm going to give you a copy here. Can you tell me, is that your report?
Yes, it is.
Does it fairly and accurately represent a copy of your original report?
Yes.
All right, members of the board, I'm going to be handing you a copy of Mr. Green's report, and I ask that it be admitted as appellant exhibit 2.
And we object to that, and we request a moment to review the report, as we have not seen it yet.
Okay, we'll give you a moment, but I think we would all like to see the report.
Give them a moment, make sure they're, let's hold until they had a quick look at it anyway.
While you're waiting, I'll say that I regret that I differ in opinion from the staff, and hope that it's a sign that reasonable people can have different opinions.
And I'm sorry, it's Councilor Osborne?
Yes.
I am getting some feedback. If you can speak into a microphone, or maybe, yeah, maybe, do it, yeah.
Oh, I thought we were waiting on the board to say we're, I thought y'all had already given, my mistake. Okay, we object to this report. Obviously, we haven't had time to thoroughly review it, but just at a glance, it conflates a totally separate application that was filed, which was for a change in use to a small hotel. It conflates that with the short-term rental vested right issue, which is completely separate from that. The small hotel is a new zoning designation defined by the city in the STR ban amendment that came along after the development application. It's defined in part as a commercial lodging operation. I'm not sure I have exactly the words right, but it is not the same as short-term rentals. It is a hotel that has its own operational requirements, and that is not at issue here. That application has been withdrawn. All we are talking about is the city's determination of the short-term rental vested right. For what it's worth, in the homeowners association law context, North Carolina courts have found that short-term renting did not violate a restrictive covenant that disallowed commercial uses. So to the extent that Mr. Green's report says this is a commercial use or it's prevented by covenants or something else that forbids commercial uses, that's not what the law says. And finally, it looks like at the end he is testifying as the ultimate issue before this board, which I understand to be improper.
So we did not get to read the letter, so we literally have no idea what you're talking about.
So I'll just...
Generally speaking?
I mean, that's our objection. I realize you haven't seen it yet. But based on a quick review, it appears to be asking the wrong questions based on the wrong information.
Have any advice for the board, considering the fact that we've already opened it up to listen to the testimony from Mr. Green, having access to this letter and reading this letter and making our own determination about the validity and
It will be up to the board. You can let them provide the letter to you. You've heard the arguments or discussion, and you can make your own determination as to usefulness of the letter. But you're going to want his testimony so you can get the points at issue addressed.
Right, so any questions that would be related to this letter, we still would not know exactly what's happening because we don't have access to the letter.
And Madam Chair, without withdrawing our objection, I think that opposing counsel was probably listening to Mr. Swords as he spoke. It might be an opportunity for them to decide whether they want to hand up the letter or if they would like to redact the conclusion or whatever they want to do. It's our opinion that it's not fit to be produced to the board.
No, I don't know that there's no opportunity for us to redact it. Mr. Green's testimony will either illuminate the letter or detract from it. You can give it all the way you want, you can give it no way you want. It's like a judge would tell a jury, you can believe all, some, or none of the evidence presented, but you have to have that evidence presented before you can make that determination.
Board, do you have any thoughts on this?
I think, personally, I need to read it and understand exactly what is being said. I think I can make my own decisions myself. I don't need anybody else's ideas in my head. I can make my own decisions myself.
Yeah, I would like to see it.
Okay.
I think,
Mr.
like I said, we can figure it
Why
out.
not?
Mr. Warnoff?
I would like to read it.
Pass it out, thanks. We'll try to read quickly. Okay, I think I was the last person to finish reading, so with that, let me go ahead.
I just want to clarify, with the board, will Mr. Green's report be admitted as an exhibit?
Yes.
Okay. Thank you. All right, Mr. Green. Back this way a little bit, and maybe that'll help just a little bit. Mr. Green, as part of your work in the planning field over the last 40 years, does it involve reference to statutes and statutory interpretation to assist you in your planning duties?
Yes,
And are you familiar with vested rights?
yes,
Are you familiar with North Carolina General Statute 143-755 and what's now 160D 108, but was previously in 2017 160A 385?
yes.
And just generally, and I will more specifically go through those statutes, but just generally, can you tell the board what you understand those statutes to mean when you're applying them in a planning perspective?
It enables an applicant to decide which ordinance standards apply to this project between the period of application to approval.
Okay, and so I'm going to pull up here 143-755, that's the first page, and then we've got the second page here. So from your planning perspective, how does this specific statute apply?
Again, it enables the applicant to select which standards are applicable to his or her project, given the changes in statutes or standards between the application itself, date of application, and the date of permit approval.
Okay, and I'm going to move now to 160D 108, and specifically, I'm going to show here section E. Yep, and you heard Mr. Golden discuss this earlier. Not really zooming in there. There we go. So for subsection E specifically, how do you apply this statute in a planning perspective?
The applicant would be able to determine which standards apply to each permit for which he or she has applied.
And so how do you typically see that in practice?
To let the applicant know, discuss the amendments or new ordinances that are planned for adoption or have been adopted between the time of application to issuance of the permit. There's also a time limit there for doing it.
Okay, can you talk more about what that time limit is and how you apply that?
The time limit is 18 months from the issuance of the first permit, and during that time period of a year and a half, the applicant can determine which standards apply to each of their individual permits.
Okay, and so is it common practice to engage with the applicant of a development project in that manner, discussing the two choices?
Yes.
Okay. So is there a perpetual opportunity to make the choice of the applicable law, or at some point does that opportunity come to an end?
Again, it's the time limit of 18 months from the issuance of the initial permit for the project.
Okay, thank you. Now, so are you familiar with the City of Asheville UDO?
Yes.
And are you familiar with the version of the UDO that was in existence in 2017?
Yes.
All right, and are you familiar with the ordinance we've been discussing, 4650?
Yes.
So based on your training and experience and the ordinance as it was written in 2017, do you have an opinion as to what choice the applicant made as to the use of the building?
Yes.
And what would your opinion be?
Based on the permit application and the zoning permit, residential use.
Now, the UDO that was in effect in 2017, does it address the use of lodging in the central business district?
Yes.
And are you aware of whether lodging was a separate use category from residential use in that same 2017 version?
Yes.
So in your opinion, do you see any ambiguity in how residential uses and lodging uses were permitted in 2017 in the central business district?
No.
So how would short-term rentals have been categorized?
They were lodging during that period.
Okay, so say if there were to be ambiguity there, if a definition is ambiguous or unclear, what's the standard practice in your industry for resolving any ambiguity?
We refer to the planner's dictionary, dictionary prepared by the American Planning Association.
Okay, and do you have in front of you, or do you know, how does the Planner's Dictionary define lodging?
It defines it as a place one stays temporarily, such as a room in a house or a hotel. And then it goes on to say that lodging can include various types of accommodation.
So does that include short-term rentals?
Yes, in my opinion.
Okay. And so knowing this, in your opinion, based on the ordinance in effect in 2017, what would the applicant have needed to indicate on the application in order to short-term rent?
Either lodging or short-term rental as a subcategory lodging on the application.
Okay. Are you familiar with section 7-5-2 of the UDO?
Yes.
Let's see. All right, so I've got it pulled up here. Go back to the portion that Mr. Golden had up before. So is a change of use from residential to lodging a change of use that would require a permit?
In my opinion, yes.
And so if a new permit is required, how long does an applicant have in this scenario to submit the permit in order to benefit from that choice of law provision in 160D 108 that we discussed earlier?
18 months from the issuance of the initial permit for that development.
And so would a permit for a change of use be the type of subsequent development permit that's contemplated in that statute that's subject to that 18-month provision?
In my opinion, yes.
Okay. And so briefly, I want to jump back to your report. And initially, we had talked about the 4 questions that you considered here. And one of those is based on precedent and the impact that the zoning determination would have on the purpose of the zoning ordinance. And so I want to ask, in your opinion, what should be considered when exploring if a decision would set a bad precedent or not?
Whether it could be applied to other questions or issues of the same type.
Okay. Is there anything else that that you would consider when you're exploring that determination?
We'd look at, again, the local ordinances, past questions, state statutes.
Okay. Is there anything outside of the ordinance or state statutes?
In this case, and again, this is in my 42, almost 43 years of planning, this is the first time the question of the intent of use has come up as different from that of shown on the application or the permit. So if I'm trying to find the intent, I would look broader afield at sales information, restrictive covenants, knowing that we do not enforce those as local government, but again, trying to identify intent, which again is a question that's never arisen, but in that instance, I would cast the net a bit further.
Okay, so speaking of this intent, and in the zoning determination letter from Mr. Collins, the city said that they've relied on the original intent of the applicant in coming to its conclusion. So, I mean, you kind of already led to this earlier, but what would you do to determine the applicant's original intent?
Look at the application, at the permit issued, again, casting the net a bit further, looking at any information that the applicant may provide to try to prove that intent. Sales brochures, information about the project, et cetera, trying to identify, to make certain the intent was there and why that differed from the application.
Talked about the restrictive covenants that are recorded for these condominiums, and I want to just pull up a specific page of those covenants here, and I've highlighted So these covenants, they talk about a sense of community. So in your opinion, do short-term rentals align with creating a sense of community like here in the restrictive covenant?
Objection. That is beyond the scope of this inquiry.
Beyond the scope of his expertise, I think.
That's okay.
That is a personal opinion.
Yes.
Fair enough. All right, Mr. Green, so in briefly wrapping up here, in your opinion, is it acceptable or appropriate to 8 years later allow a change of use from residential to lodging at 17 North Market Street?
Objection. On the grounds that it is, on the grounds that this is a legal conclusion and central issue in this case, it is not appropriate for this expert to level his testimony.
I'm sorry, can you repeat that again?
It's on the grounds that the question calls for a legal conclusion and an issue that is at the center of this case.
The city joins that objection.
We'll pass on that one. Okay. So, in your opinion, what development regulation would apply to 17 North Market Street owners attempting to rent their units?
As of today,
As of today.
the ordinance is in effect today.
And what would they need to do in order to short-term rent their unit?
They would have to apply for the permits,
And is that currently permitted under?
not in the CBD.
Okay. That would be all my questions.
For the record, we'd like to object to the answers given by the applicant for those last 3 questions.
So noted.
City has some brief cross-examination. You heard Mr. Collins testify in his professional opinion as a planning expert that restrictive covenants are beyond the scope of a planner's review of a land use permit, didn't you?
Yes.
Do you disagree with that?
I agree that the local government is not an enforcer of restricted covenants. The question that was raised about intent is something new to me. I've not experienced it. In my opinion, you would look broader afield to identify the intent, to verify the applicant's statement that the original intent was.
But you would agree that restrictive covenants are basically not relevant to a land use analysis, right?
Not relevant to enforcement, but to provide a broader picture of the land use, they may come into play.
Can you think of any context in which they would be appropriate to consider from a planning perspective?
Again, trying to improve intent of what the development was, the purpose of the development.
Okay.
Again, that question, the intent is a new question. I guess it's wrong that there's nothing new under the sun. There's always a new perspective.
Didn't you also hear Mr. Collins testify that planners are actually educated to specifically not look at private land use restrictions?
You know, in all my years, I've never been educated that we don't look at them. I've been told many times that we can't enforce them.
You've been told that you cannot enforce them?
Cannot enforce.
Okay.
Local governments do not enforce restrictive covenants.
Okay. And did you didn't hear Mr. Collins testify at any point that lodging is a type of residential use, did you?
No, I don't believe so.
Doesn't your report that's been entered into evidence seem to state in several portions that that was the city's position?
No, I don't believe so.
Just a moment. I'm looking at sort of starting at the bottom of page 3, going into page 4, you refer to definitions of lodging and argue that short-term rentals meet the definition of lodging, but Mr. Collins didn't testify that short-term rentals are not lodging, did he?
Not that I'm aware. And I admit I was looking at background information somehow, Mr. Collins.
You also testified that in the event that there's ambiguity in a land use ordinance, that it's the common practice to refer to the planning dictionary. Do you know when the last planning dictionary was published? Off the top of your head?
Not off the top of my head.
Is it possible the planning dictionary could be out of date at this point?
I would hope not. Again, a lot of ordinances in the definition section state that if a definition is not there to refer to the planner's dictionary.
And isn't it true that when there's ambiguity in a land use ordinance, the land use ordinance should be construed in favor of the free use of land?
Correct. Again, the ambiguity that's settled by the planner's dictionary is only in the definitions of terms if they are not defined in the ordinance itself.
I don't have any further cross-examination. We can move on to if the appellees have any.
Briefly, Madam Chair, I will be quick. I'm going to ask a few questions, and if it's okay with the board, Mr. Swords will ask a few more questions. We're just trying to get through the report. All right. Mr. Green, in your investigation, you did not talk Sorry, in your investigation, you did not talk to the developers of this project, did you?
No, I did not.
Did you talk to Mr. Collins?
Not on this question, no. I relied on his letter of zoning determination.
Okay, you had no conversations with Mr. Collins about this? Did you talk to any other planners?
No.
Did you have the same information that Mr. Collins did before coming here today?
I had a lot of the same information, but not all. I imagine he spoke with you, with the developer, and I did not do that.
And you don't have Mr. Collins's expertise in interpreting the current UDO, do you?
Likely not.
And you don't have Mr. Collins's expertise in interpreting the 2017 UDO, do you?
Likely not. No. Only sections of it that were relevant to this.
How many times have you been hired to be an expert in the planning setting, testify like you are here today?
Can't recall them all in the last 2 years, I think 5 times.
And is this something you're doing for free?
No.
Are you being paid to testify here today?
May I ask you, are you doing this for free? I don't think that's relevant to this hearing.
It's a simple question.
It's not relevant to this hearing.
If you would please just answer the question for this board.
No.
I think if he's a
refuse to
paid
answer.
consultant, that's fine, just as you are. I don't think we need to dive into how much he's getting paid.
Did you talk about your testimony today with the applicant's attorney?
No. Or the applicant for the appeal I did, but not the zoning permit applicant.
Can you tell us about those conversations?
No, they're legal. I'll look to my attorney.
Normally object, but we think you understand what the contents of those conversations were as it relates to the report that was handed up to you. So he was hired in anticipation of litigation. This is quasi-judicial. We could ask for protections, but Mr. Green is not our client.
I spoke about this.
Well, I'll just ask you one specific question then. Did the attorneys give you an outline to help you prepare for this?
No.
Okay. Did the attorneys help you at all in writing your report?
They asked me to take out one line, which was that with this, we give the applicant a get out of jail free in the deed to Park Avenue.
I have a couple of questions about the definitions we talked about. So you testified that a planner's dictionary defined lodging as commercial, is that correct?
Said it defined it as a place for short-term stays, and then I gave the definition of commercial from the planner's dictionary.
Okay, so you didn't testify that a planner's dictionary said that short-term rentals were commercial? Are you aware that the planner's dictionary is a collection of examples of how various zoning ordinances across the country have defined certain terms?
Yes.
So these are not definitive definitions, are they?
No.
So in that regard, might the current Asheville UDO definitions be relevant to whether a short-term rental is commercial or not?
Yes.
Let's see, unless I can get it up on the screen real quick, I'll just read the definitions. Okay. First, let me start with the hotel definitions, and I'll go with hotel, comma, small. Means a commercial lodging establishment under single management with on-site supervisory personnel containing 7 to 35 guest rooms offered to the general public for transient lodging accommodations, and which may contain ancillary facilities or services such as dining areas, exercise rooms, swimming pools, and meeting rooms. This definition shall not include extended stay hotels. Does that definition characterize a small hotel as a commercial lodging establishment?
Because of the first sentence, or first phrase.
Okay, now I'm going to read the current definition of short-term rental. Short-term vacation rental means a dwelling unit with up to 6 guest rooms that is used and/or advertised through an online platform for transient occupancy for a period of less than 1 month. A short-term vacation rental is considered a lodging use under this UDO. Does the short-term vacation rental definition currently in the UDO characterize short-term vacation rentals as a commercial use?
No, most definitions do not identify the type of use. Where we find those is in the permitted use table. For example, in the UDO, it has commercial business or office as a category of uses. As you scroll across, the lodging, and in the CBD expansion district, it's lodging. Short-term rental is included in the CBD expansion district is under that category. It's also, I believe, in the office institutional zoning district categorized as a commercial business, a commercial office or institution.
A dwelling unit refers to a residential dwelling unit. Would you agree? Okay. So this short-term vacation rental definition calls it a dwelling unit, and then it also specifies that it's considered a lodging use under the UDO. Does that indicate to you that certain lodging uses may be residential in nature?
Indicates to me that the owner could live in the same structure as short-term rental is provided. For example, I had a home in Knoxville that has a separate apartment in the basement that could have been used as a...
Let me just step in because you're referring, there's a separately defined term called a homestay.
Yes.
That talks about, owners living in the same structure. I'm just talking about the short-term vacation rental definition. I think those are my questions. Thanks.
Thank you.
I would just have one more redirect question, if I may. Mr. Green, based on all of these questions asked of you today, have any of them changed any of your opinions provided or given in your report?
No.
Okay, that would be all my questions.
Thank you, Mr. Green.
Okay, did you have any questions?
Well, that's a good question. Does anyone have any questions for Mr. Green? Not at this time. I do. Oh.
I do.
Thank you, Mr. Warnell.
No problem. Yes, ma'am. Mr. Green,
In your report that we got, you mentioned 4 questions that need to be asked when assessing an issue like this. Are those 4 questions found in a planning standard, or is that a style and technique issue of your own?
Style, as far as I know, it's a style of my own that was first directed to me through a course at the School of Government. Back then, I think it was the Institute of Government. And then we started using it. Patsy Meldrum Bryce and Bryson Meldrum, can't remember the order, who was a staff on the city attorney staff here as an attorney to the planning board, and I discussed it. Again, the most recent time that I discussed it was in the preparation of the city of Knoxville zoning ordinance, talking to the city attorney about the process for interpreting the ordinance.
Thank you very much.
Thank you all for your service on the board. I know it's not easy.
Thank you, Mr. Green.
We just have one more witness. We're going to make it brief because we know we're pushing 5 o'clock and everybody needs to get home. Mr. Pierce, come on up, just real quick. I think you've been sworn in.
Yes, sir.
Have a seat. Just a couple of quick questions. State your name for the board and your address.
Kenneth Pierce, 17 North Market Street, Unit 402, Asheville.
And how long have you lived at 402 17 North Market Street?
June 21.
Were you one of the first individuals to purchase there?
Yes.
And there's been a legal argument and a booklet submitted to the board for their consideration. Part of the attached exhibits have several email communications between you and other individuals. And so those they've been introduced, they've gotten them. Tell the board what those are going to say, because we didn't get a chance to look at them before.
What the emails are about, there's 3 board members in the HOA. I'm one of them. The 2 developers are the other 2. The 2 developers have the STRs. I don't. Early on, it came up, some members had raised the question at a meeting, actually in 21, about whether short-term rentals were allowed in the building. They had understood that it was not allowed under Asheville ordinance, and that people shouldn't be short-term renting, that they were told in the buying process that there would be no short-term rentals. And so they were upset that they moved in, they bought the place, and now there were short-term rentals. I took a look at it. I took a look at the documents to answer them. I'm an attorney. It has nothing to do with land use, though. And in those documents, there is, in the ordinance, or in the declaration, there is a provision on leasing allowed, or there was. Doesn't distinguish short-term or long-term leasing. But then there's also provisions about residential use that is for development of a community, and also that anything that is done with the unit by any owner has to be in compliance with local, state, and federal law. So the question came up, well, and I wasn't that familiar with the ordinance, well, how can they be renting if it's not in compliance with law? That's not personal use. What's the answer here? People would ask me, and I would tell them, well, the HOA documents do say that leasing is allowed, but there's all these other considerations that may come into play. And this really isn't my area of expertise. So I proposed to the board, the 2 developers, why don't we get a legal opinion on this? I can't really say what the answer is. This isn't my field. That was in 22, and I was voted down. They didn't want to know the answer and get a legal opinion on it. And so we were left with the muddle we had, and then the years of fighting that ensued until there was a proposal to turn the building into a hotel, and then the real fighting started.
And so you think those email correspondences that are attached to their legal brief are reflective of what the testimony is that you just said?
Correct.
You saw Mr. Collins' zoning determination letter, and I'm going to put it up there since we've been talking about it. You're familiar with this zoning determination letter, are you not?
Yes.
All right. And as part of that zoning determination letter, Mr. Collins talks about the investment that such you have supplied information to the city indicating that, one, the investment in the redeveloping 17 North Market was made with the original intent that the property would be used short-term rental purposes. You heard his testimony. Were you here today? You heard his testimony?
Yes, I did.
Is there any information that you have that would contradict the fact that the original investment was made with the intention to be used as short-term?
Well, again, I would go back to the declaration. I heard the testimony about it's not being used by the planners, but if you're looking at intent, that's probably well expressed in the declaration. And the declaration does say residential personal housing, and it talks about in terms of community, which you had brought up before, which is not consistent with transient use, which is what short-term rentals are.
All right. And these declarations, they were filed with the Buncombe County Register of Deeds on March 15, 2021. Do you recall that?
Yes.
And you bought right thereafter.
Yes, correct.
Also, is there any other provision that you talked about as it relates to leasing that would indicate a contrary intent, as expressed to Mr. Collins by the developer, that short-term rentals weren't going to be contemplated? And I'm throwing up to you the use restrictions. Are you familiar with this one that's highlighted?
Yes, I'm familiar with that. That was never done.
So a true executed copy of any lease for a unit shall be provided to the association prior to the occupancy by the tenant for such use.
No, and I raised objection to that about the board. Why isn't this being done? The HOA doesn't know who's in the building. We've got strangers all over the building, and we don't even get to see the leases or know who's in there.
So in 2021, when the declarations were filed, do these show a contrary intent as far as short-term rental allowance?
Overall, the declaration overall shows to me that short-term rentals should not be allowed, particularly because they're not consistent with local law.
You recall that the planner doesn't rely upon, read, or review
I recall
short-term
that.
rentals.
I recall that.
Right? But they brought in the intent of the original developer. Correct. Those would be my questions, Mr. Pierce.
Just very brief cross-examination. Mr. Collins' zoning determination letter was issued to the law firm of Allen, Stull, and Kilburn and representing the applicant to develop the property, right?
The determination letter?
Yes.
Yes.
And you weren't one of the developers of the property, correct?
No, I'm just an owner. I'm a resident that lives there. No, it surprised the heck out of us when the February 17th and February 21 letters came out. We weren't involved in the process. There was no comment process. There was no collection of facts. We had no participation at all in that process and didn't know it was happening. And it hit us out of the dark. I don't know what's required by the city's regulations. I don't know if it just didn't seem very fair. And they knew we were involved. We had been fighting and arguing about this for over 2 years. And to make a determination like that, factually based, somebody who would know the facts wasn't allowed an opportunity or invited to comment or participate, it's not right. It's just not right the way it was done. We would have a lot to say if this was open to, if we find out that the record is different than these questions, as you said in your letter, believe me, we got a lot to tell you about that. We'd love an opportunity to do that, but we've never been given one.
But given that you and other residents of the building weren't involved in that process, Mr. Collins had no way of knowing what your impressions of the intent of the original use of the building were when he issued the determination, did he?
Could have asked.
And I believe you agreed earlier during your testimony with Mr. Golden that these restrictive covenants are not in fact relevant to Mr. Collins' determination, right? You agreed earlier when Mr. Golden was testifying or questioning you that these restrictive covenants are not relevant to the land use determination issued by Mr. Collins, correct?
I was saying I heard that testimony. It's not my field. I don't know what's relevant or not. I really can't say.
Fair enough.
But I heard him say that.
I don't have any further cross-examination.
Mr. Pierce, you read the declarations of 17 North Market Street condominium prior to purchasing your condominium, true?
That's true, yeah.
And after you read them, you knew that they specifically allowed STRs, correct?
Well, they don't specifically allow STRs. They never make a they don't distinguish between long-term and short-term. It just says leasing.
May I approach the witness? Just a hand.
And if I could interrupt, just so I can put this stuff up on the screen.
All right, you're being handed what I've marked for identification purposes as Exhibit A.
Right. Do you want it back?
No, that's all. We'll have it on the screen. I'm going to hand out paper copies as well. Thank you. All right, Mr. Pierce, as you can see from the highlighted portion, on February 13th of 2022, you wrote, "So it goes. I read the docs and knew that." And you were talking about the STRs, right?
About leasing, yes. Yeah, yes, STRs, yes.
Specifically, you read the docs and knew that STRs were allowed.
I knew that I knew that Exhibit D had a provision that allowed leasing. That encompassed STRs, yes, I knew that. I also knew, as stated further down in that paragraph, that there's questions about the city and it's illegal. And if it's illegal, it's illegal. The reason I say that is because the answer that, and another one of the developers was pressing on everybody about why we could do this when the city clearly didn't allow it, was because the HOA docs take precedent, supersede, and authority local law. And I knew that was crap. And he said, well, there's also something pending down in Raleigh that's going to take away the authority of cities to do this. So therefore, it's going to be allowed. And I said, well, and then he went into the Wilmington case. I said, well, Brad Barnum, the city attorney, said in the paper that the Wilmington case really doesn't change local law. And then he said, well, Brad Barnum's wrong.
Mr. Pierce.
That's what happened. You want the explanation for this? There's background to it.
Mr. Pierce, I would like for you to answer my questions directly and concisely.
I'm just going to object to his scolding the client. If he asks an open-door question, my client has the ability to walk through it, and I think he did. When he asked him about this, what it meant, he could explain his answer, so I'm going to object to the scolding that Mr. Freeman just gave my client.
I meant no offense, Mr. Golden or his client. I believe it was a yes or no question. All right, Mr. Pierce, if you will please turn to the third page of the document I showed you. This is what was actually being discussed. The process for 17 North Market Street condo building was started before the ordinance banning short-term was voted on and intact. I know the state of NC law about this, and so does the city of Asheville. Those laws are, from my understanding, in conflict with each other. Regardless, the 17 North Market condo rules and regulations have always been set up from the beginning to allow for short-term rentals. I believe that we would have 100% of owners agree to banning this.
You know, that's not me.
I understand.
That's
I
Brett
understand.
Kruger. That's the other
Brett Kruger.
developer I was telling you about.
Right? Did I read it correctly?
Sure. Did you read it correctly? Yes, I read what you read. I'm not sure your point.
So I think it may clear up this next line. Mr. Kruger writes, "I specifically allowed them in our restrictions so that no one would ever question or argue about." That is when you said or wrote, "I read the documents and knew that," correct?
If that follows after it,
And y'all, just a reminder, please speak into the microphones. Please speak into the microphones.
I don't object to that.
And moreover, you were involved in drafting the 17 North Market Street Owner's Guide, true? In fact, you drafted the first version, correct? In that first draft, you expressly wrote that short-term rentals are allowed under our HOA's governing documents, correct?
Yes, I wrote that, as well as the warning to the people that the law is ambiguous and in doubt. It is up to you to check it on your own. There were two versions of the manual, right? There's the draft, and there was the final one that could get approved by the two board members. You're aware of the draft.
Would you like to see a copy of the first draft? Can we pull that up?
We're not going to object to this being handed up without first being authenticated. Out of time constraint, but I've asked the board not to look at it until we can get at what it is. And I will further object, because if they are now asking about what my client believes these declarations say, we're opening up the door to 3 or 4 more hours of testimony. And I think by putting in email communication between the developer, if they're trying to prove intent, they can't prove intent of their client through mine. They need to have their client up here. So
That is not the first draft. That's the final draft.
So, and we'll just object on relevance to cross-examination of Mr. Pierce as it relates to what he did.
There was a draft that also stated that, may also stated that it may be, if you're going to ask me a question, I'm going to answer it.
Objection, there is not a question pending at the moment.
Well, hold on just a second. So, Mr. Sneed, at this point, do you have any advice for us on this documentation that we've already received? And do we need to just, for the record, accept this as evidence in some capacity of which we don't have any knowledge?
What you've just been handed has, as Mr. Golden pointed out, has not been identified or authenticated. And so it's not a document you can rely on until that happens.
Okay, so we have received something I don't think anyone has read, the second set of documents. This first set looks like an email chain between Mr. Pierce and Mr. Kruger. I'm not entirely sure who Mr. Kruger is. So,
Had testimony as to what that document contained.
right, was a little hard to follow.
And Madam Chair, I apologize for that. I believe Mr. Goulden is correct. I probably handed that to you a little too soon. I think we're all trying to get this wrapped up as expeditiously as possible. However, I have no problem before any board member looks at that document to lay proper foundation. I am just trying to move forward a little quickly. These emails have already been submitted to this board. I think they speak for themselves and they are relevant, but I am happy to lay proper foundation before moving forward.
In a brief elevator pitch type of way, if you could give us a summary as to what these documents are, that would be great.
Mr. Piers, we were talking about your participation in drafting of declarations. Did you have email communications regarding the same?
I didn't draft the declaration.
I'm sorry, the owner's guide.
Yes, I drafted that twice.
Did you have email communications with David Hitch, Brett Kruger, Charlie Caputo, and yourself on March 7th, 2022 regarding your drafting of the declaration, or I'm sorry, of the owner guide?
Yes.
Okay. I've handed you what I've marked for identification purposes as Exhibit B. Is it a fair and accurate representation of that conversation? I'm sorry, is it a fair and accurate representation of your email in that conversation?
You know if this is the first draft or the second draft?
I'm just asking about the email at this point.
You don't know.
I do. Does the email that I've shown you, is it a fair and accurate representation of the email that you sent on March 7th? It's the first page.
Yes, that's my email.
And can you read the highlighted portion for me?
Attached is my promised draft of the 17 North Market Street owner's guide.
And if you look at the top of this piece of paper, it names the PDF. Can you read that, please? It's in blue.
Yes, 17 North Market Street owner's guide.
Can you tell from that title whether this is the first or second draft? Can you tell from your email whether this is the first or second draft?
I can tell by what it says under unit rentals, whether it is or not, because there was a change there.
And I'm going to object to the ongoing questioning. I'm trying to allow them deference as to what they're asking. But as far as administrative determination, they haven't shown how this ties to it, whether it's binding on anybody or what it actually means, what the authority that it has. And without going through any of that, we are spinning our wheels trying to prove that Mr. Pierce wrote something that is not relevant for this board to consider when they make zoning determination.
Madam, this is being offered to the board solely as impeachment material to show that Mr. Pierce's testimony that he did not think that STRs were allowed was not accurate because there's a writing that says he thinks that it was.
I thought it was ambiguous. I thought the leasing was allowed in Section D of the declaration. That contradicts other sections of the same declaration. Some places it's allowed, some places it's not.
And I don't want to make this a legal argument as far as impeachment. The questions I asked were specific. Is there any indication about the developer's intent that is contrary to the finding that short-term rentals were allowed? It doesn't go to anybody's intent. So we'll renew our objection.
Okay, so, I'm not a lawyer, I'm not a judge, but we are here to either uphold or overturn a city determination, not getting into the weeds. I understand the need for laying a little bit of groundwork for intent, and unless my colleagues up here feel otherwise, I think that we have kind of exhausted this homeowners information, and does anyone else feel strongly one way or the other about that? I'm more interested in the legal definitions, the city process, the notice of violations, the applying for short-term rentals, all of these things that are related to the UDO and permitting and this appeal in relation to short-term rentals for 17 North Market Street. Does anybody have a strong thought about that? Or Mr. Sneed, am I jumping the gun?
It's appropriate if this board.
I concur with Madam Chair. You know, all the other things are, for me, are diversions from what we're here to do, the work that we're intent to do. I'm not interested in, quite frankly, in any other stuff. I'm here to make a decision, and the decision's going to be based factually, and that's it.
Mr. Sneed, do you have any other advice?
And as Brandon was pointing out, a lot of his questions, all the witnesses were to undermine his testimony, basically. His initial testimony was, or at least you got the impression he was saying that the people who were buying in didn't know there could be short-term rentals. He offered evidence that showed that witnesses, in fact, knew there could be short-term rentals. And that was impeachment of the witness, is what they call it. And you show that perhaps he didn't, his recollection was wrong, but his statement may have been incorrect, and so that you know how much weight to give it. But I think you're telling the attorneys you've heard enough that you can make that call.
I think we know that the HOA, I think we've heard that, and that really doesn't strongly affect it one way or the other. Yes. Mr. Cletus, Mr. Ryan?
I don't have anything else to add to this discussion.
I think we got the subtext, guys. You can move on.
Madam Chair, we are prepared to move on.
Great, let's do it.
If I may ask one simple question for the record, without any specific questions about it, did you draft those declarations?
Objection or not declaration?
I'm sorry,
Other than that,
I apologize.
other than that, sorry.
Did you draft the owner's, owner's guide that I'm holding up? Okay. And my final question, it is true that you applied for STR use under the very determination that you were appealing here today, true?
With reason, yes.
Those would be my questions.
Okay, Mr. Sneed, where do we go from here? I'm a little bit lost as to where we are in this process.
And unless there's a redirect by Mr. Golden, I think you're.
No, that would be our last witness.
And then whether the city needs to call rebuttal witnesses, whether these folks need, I'm losing track of who's who, need to call rebuttal witnesses. If they
Yeah,
don't,
if that's Mr. Golden's case, then it would move on to the city's case.
Then let's do that.
May I request a 5-minute break first?
I would love for you to request a 5-minute break, and do we need to make a motion to return in 5 minutes?
I motion to return in 5 minutes.
Second, all in favor? Aye. Aye.
Aye.
Great.
Oh, I got it. Oh, thumb stiff.
Yeah. Got a little sloppy. This one got a little sloppy.
That's his phone. I'm not going to stop him.
no, no worries.
Yeah.
Down the hall that way. Yes. Yes.
far as? I'll get those to you.
Yes, yes.
Yeah, yeah, I haven't heard that I haven't heard that in forever.
No, go ahead. Yeah, 5 minutes.
Yeah.
I think I'm over my meter time at this point.
I go to the parking deck at DS at night.
We're supposed to because we get. I went and got a coffee before.
Oh, no, down here. Where's the closest? We got some right there, right? I would love to read history. So security guys were saying they weren't getting scheduling docs or something?
Over the dark side like he did BYD.
City to
Go to the dark side.
Yeah.
Fine, City Hall?
These guys are taking us out there.
Yeah, go up there and I'll ask you questions. I'm already looking like,
Talking to each other, forgetting we're.
Oh, I can't figure out how to quit.
Yeah, I can't even think where the city would go.
it's like,
I do miss it, but it's
yeah.
Out front.
Right.
There's some visitors over there.
I've still got.
So it's, usually like the little.
I just go out there. I just go down the street.
Waiting, I'm having the hardest time finding the permitted use table in the UDO. Is it down in the appendix, or is it at the bottom of the use district? I cannot find it. Yes, and I know it's like the drop down, and it's weird. I'm in 7, maybe Sam knows. Sam, can you find the permitted use table?
Yeah, I'll walk out with you. Just kind of,
In the-
because I got to go back around.
Okay.
Permitted use table?
yeah, I saved it as a Google sheet. But if it ever gets updated.
Okay. Well, I didn't gavel us out, but I guess I can gavel us back in regardless. So we are back. And I believe we were going to the city?
Yes. The city calls Chris Collins.
All right.
Chris, I provided you and the board, as well as the other council in this matter, with a record of the administrative decision. Do you have that available for reference?
I do.
And for the board, we've been referring to this record kind of throughout the afternoon, and it's something that the city is required to put together as a part of this appeal. I have not had the chance yet to make a formal motion to enter it into evidence, but if you'll allow me to lay a foundation and then make that motion. Is the record the complete record of all the documents you considered when reaching your zoning determination, to the best of your knowledge?
Other than a few quick glances at a permitting system screen to see some records, some record numbers, not actual records, yes.
I'd like to make a motion to enter the record of the administrative decision into evidence.
No objection.
I'm like, does anybody, we're fine? Okay. Okay, great.
Thank you. With that done, can you, Chris, please refer to item 2 in the record, which is ordinance 4560?
Yes.
What is the date of adoption of this ordinance?
Let me get to the end of it here.
I think there might be a cover page too.
Looks like February 14th, 2017.
Can you just briefly describe, with respect to lodging and level 2 developments, what this ordinance accomplished?
Ordinance 4560, give me 1 second to get 37 and 60 straight back in my head. 4560 set forth basically it touched our different levels of development review within the city, and it set forth a situation by which lodging establishments with up to 20 guest rooms could be reviewed by right as a level 2 development, and set out where those could happen in the city and what districts.
Can you please refer to page 17 of item 2 in the record?
Okay.
At the very bottom, what does it say that this ordinance changed about lodging and level 2 developments?
In Article 8, subsection J, is that where you're referring? Okay. It says that the permitted use table shall be revised in the following ways. Under the lodging heading, add lodging facilities, 20 guest rooms or less, and donate P, permitted, in the cells corresponding to the following general zoning districts: CB1, CB2, NCD, HB, RB, C1, CBD, RZRT, which is resort, institutional, river, UV, and UP.
Thank you. That's fine. You can set aside that document for now. Can you please refer to item 3 in the record?
Yes.
What is this document?
This is the application that, excuse me, these mics are really finicky. This is the application that was submitted for the level 2 site plan review for this project.
What type of development did it apply for?
Level 2.
What is the date on the application? I believe if you refer to the owner's affidavit on around the 5th page.
December 14th, 2017.
So was that before or after Ordinance 4560, the ordinance that we just looked at?
That was after 4560, yes.
Thank you. You can set aside that one for now, too.
Okay.
And can you please go to item 4 in the record?
Yes.
This is Ordinance 4637. What is the date of adoption on this one?
This was the 9th of January, 2018.
Was this before or after the application that you just looked at for 17 North Market Level 2 development?
This ordinance number 4637 was adopted after the application was submitted.
What did this ordinance, very briefly, kind of accomplish with respect to short-term vacation rentals and other lodging uses?
In regard to this conversation today, the most essential thing here is that it removed Lodging, it removes short-term rentals as an allowed use within the central business district.
Yeah, you can set that one aside for now. And can you please look at item 5 in the record, which is the 17 North Market zoning permit?
Yes, I have it here.
When was that issued?
This was issued, excuse me, May 25th, 2018.
And what, in your opinion, based on the timing, the timetable that we just discussed, what would be allowed at this property based upon that timeline and based upon the permit in item 5 in the record?
The time period of this application, what was allowed would be based on the application date rather than the approval date for this level 2 application. So the allowances would be based on, well, the most closest in proximity to the application submission. Before it was 4560. So the allowances that were changed with 4637 would not have applied to this application. So short-term rentals within the CBD zoning district would be allowed when the application was submitted.
Under what type of use in the land use ordinance table of uses applicable at the time of the application?
It would be those applicable with 4560. Let me see exactly how we phrased that. It would be a lodging use at that time.
Would you consider short-term rentals to be a lodging use?
I believe we did at the time, yes. We, the city, sorry.
You can set aside number 5 for now. Okay. I'm going to ask you to look at item 6 in the record, and please just briefly describe. There's, I think, 6 subparts, 6A through F, and just briefly describe what they all are. You don't have to do it individually.
Okay. So item 6 is the appeal that was filed in response to these zoning notices of violation. That's 6A. With an owner's affidavit signed by Brett Kruger. So this was appealing the notice of violation that was issued to units for operating as short-term rentals. Get to be item B. Is again an appeal filed against notices of violation for short-term rentals. Item C. Sorry, there's been a lot of documents today. Give me a sec. Again, is appeal to a notice of violation or citation. And item D is another appeal to the notices of violation that went out.
I can just, you can stop there.
Okay.
I would represent that they are all several appeals of notices of violation. When did you first become aware of short-term rental uses at this property?
The record lists a July of 2024 notice of violation, and however, we were aware of short-term activity there before that time. We are not, planning and urban design does not reside within the same department as the city's compliance and enforcement team, but we work closely together. So I had been receiving inquiries from the city's compliance team for some time before that. I can't give you an exact time frame, but it was before the official NOVs and citations that these appeals apply to, likely months before.
What happened after receiving these appeals of NOVs? What did you do / the planning department do?
After receiving these appeals, we pulled all the documents, all the records, a lot of what you see here now, the site plan, the applications. We came back in first to find, hey, this application was filed before the allowance for short-term rentals was removed from the CBD zoning district. Then we dug further into activity we had documented. So how long had we been aware of short-term activity, rental activity at the site, and what our other systems tell us about what activity was going on at the site, as far as in other systems being things we use to identify short-term rentals for compliance purposes. And all communications we had. Of course, our ongoing tool would be the zoning ordinance, which is tracking down what the ordinance looked like in 2017 and how it changed over time, right? For these ordinances that were referenced in Carly's questions, to find out what the allowances were when the application came in and how the property had been operating. We did have communications with the property owner's attorney at times because they were representing the folks who filed these appeals, and we were responsive to those. Worked internally with the, worked internally as the Planning and Urban Design Department to come to a conclusion that we did need to write an official determination on this site. Pulled the documents together to find out what that would be, given the zoning that was in place at the time the application came in, and the documentable activity that we could find in the preponderance of the units in this development.
Is there anything else you looked at before reaching that zoning determination letter, or does that about sum it up?
That about sums it up. Like I said, the only thing that's really not shown in the record is looking at just various screens of our permitting system to see how long we could document the short-term rental activity continuing on the property. But a lot of that was just records that existed, Y1 line, complaints that come in and things like that in various methods.
Was lodging an allowed use at the time of this application?
Within the CBD zoning district, yes.
This property is in the CBD zoning district, right?
Correct.
What is your professional understanding as a qualified expert in this matter in planning about how permit choice and vested rights work?
How permit choice and vested rights work? Well,
and as applied to this?
Permit choice is really simple, and it's a concept that exists all over the country, not just North Carolina, but in North Carolina, it's permit choice, and we phrase it to say that if anyone files an application for development and the laws change within a time period after filing that application, then the applicant has the ability to choose whichever version of the law that was in place when they applied or the law that is in place after the change to abide by. That's the long and short of it. It is something we're careful with in the planning department. There are reasons in state statute that it carries some risk of making the wrong decision on. So we do try and be carefully document and move those cases along forward in a correct manner.
Does it matter if the application lists a specific use to gain vested rights and permit choice rights, or does that right arise by operation of law?
That right would arise by the operation of law and the entitlement of the property, right? When the application was submitted, what zoning uses were allowed to continue there. and how was the property operated afterwards. So again, that's what we looked at, and from my professional opinion, it has to do with what was allowed by the zoning when the application came in and how the property was used.
And at a minimum, if a development ordinance is ambiguous as to whether a certain use is allowed, what is your professional procedure for determining if a use is allowed?
Could you restate that for me one time?
If a development ordinance is ambiguous at a minimum about whether a use is allowed, what is your professional procedure for determining whether a given use is allowed if the ordinance does not directly address it?
Oh, I mean, we have to, get my words right, I mean, we have to operate carefully, and if it's not specifically called out in the ordinance that something cannot be done, we're going to move likely in favor of the applicant or landowner in a situation, because we have to be able to document our no's and our decisions on the word of the law that we're given to work with.
Going back to this zoning determination letter, who did you speak to when ascertaining intent of the developer?
I know I was speaking with someone from ASK Law, relaying information from their client. I honestly can't really remember which attorney. It may have been Attorney Swords.
Do you know who they were representing?
The appellants in these cases, yeah, from item 6 in the record.
Do you ever, in your role as assistant planning director, consider private land use restrictions with regard to whether a land use is allowed?
No, we definitely don't. And if I misspoke earlier, it's not something that comes through formal education. That's comes from the school of actually trying to regulate land use throughout the years. So we do try and steer clear of that because it can bring up some pretty serious implications for us if we try to enforce it or if it looks like we are.
If the development is a multi-unit or multi-tenant development, would you ever interview other unit owners to ascertain intent of an original development?
Generally, no. I have not ever done that. That comes kind of outside the scope of what we do. We try and look at factual-based documents. We try and look at things we can prove in this case. And for us, in this case, we could prove a continuous operation of short-term rentals at the property. So really, we didn't consider a lot of anecdotal or interview evidence anywhere to make that determination.
Did the application need to list short-term rentals as the intended use of the property to obtain vested rights?
To obtain vested rights, no, the application came in when that was an allowed use within the district. And short-term rentals was not a use that was out there at the time in the ordinance, and that gap between the two ordinances that have been mentioned in these questions so far. It listed condominiums, and they are condominiums either way. That use is an accurate depiction.
Just to wrap up quickly, can you please look at 8A and 8B in the record?
I think I have just 2 A's.
Oh, no.
But I've got it. It's okay. Here we go. Okay, I have them now.
Can you briefly describe what they are?
8A is the zoning permit that was issued for a development at 55 South Market Street, which has been referenced in earlier testimony tonight, for a condominium development for 70 units.
What is
let's
B?
see. What?
What is B? 8B?
Oh, sorry, I stopped today. B is an amendment application for a development at 45 Ashland Avenue. And this amendment application was, well, I'm just going to, this is the easiest thing to do is read this first sentence. The purpose of this zoning amendment is to clarify the residential units in the project that will be allowed to be short-term rental. All of the units on the 30, 40, and 50 levels are allowed to be in short-term rental classification.
Are both of these properties in the ZBD district?
These are both in the central business district, yes.
Are these applications and amendments respectively exemplary of other applications received around the time period of 2017 to 2018?
Yes.
What makes them different from 17 North Market?
Both of these have greater than 20 units, so it became important upon the changes of ordinance, upon the changes that allowed 20 or fewer guest rooms by right. These were both level 2 developments, like 17 North Market, when they were approved originally. When the ordinance came forward and set up an allowance for lodging units up to 20 guest rooms, both of these developments wanted to take advantage of that, but in order to do that, it was necessary to identify, in this case, the 20 units in each property that would be taking advantage of that allotment. And again, the difference here is that 17 North Market contains 13 condos, which is below the threshold of the number of lodging units that could be established. There was no need to identify 20 or fewer units that were going to be used.
Do you stand by your zoning determination that is item 1 in the record based on what you've heard today?
Yes, I have not heard anything today that changes the zoning determination that's in the record, in my mind.
Thank you. I don't have any further direct examination.
Just a couple of follow-ups, if I might. Hey, Chris, Brian Golden here. Good to talk to you.
Hey, Brian.
Just wanted to follow up. Your testimony was that at the time in 2017, when this development application was submitted, that the city, you said, city treated STRs as lodging units. Is that correct?
Yes.
And you're aware 143-755, 168-385, they allow the development applicant to choose whether they want if an ordinance changes, they get to choose the first one or the second one, right? Correct? And so on May 25th, 2018, after ordinance 4637 was adopted, outlawing all short-term rental in the central business district, the applicant chose the zoning permit for 15 residential condos. You recall that?
I recall the application listing the existing use as condominiums and not a change of use. Which document are you going for here? Yeah, it's in here somewhere.
Pull it up. But the zoning permit that was issued on May 28, 2018, after the adoption of 4635.
Guess I'm getting older. Yeah. Let me get it where I can read it. The listing of conditions does list it, I mean, it's right there, listed as 15 residential condos.
And from what you're saying, because the other condos at 55 South Market Street and 45 Ashland, they came in and said, we want to identify the 20. This applicant had all the opportunity at that time to come in and identify all of the units, all, whether it was 15 or 14 or now it's 13. They could have come in and done the exact same thing that 55 and 45 did and say, we want all of these for the lodging. Couldn't they have done it?
They certainly could have, yes.
Did they?
Not that I know of. As I said before, though, we did not make a campaign to go out and set up an application process or awareness of this or anything like that. We just had a couple of developers approach us.
Those would be all my questions.
Okay.
Thanks, Chris.
Sure.
No questions, Madam Chair.
I don't have any redirect.
No redirect? Okay.
And I don't have any further witnesses. No other witnesses.
Are you calling any witnesses?
No, Madam Chair.
Well, seeing as I think this is the end of all this testimony, do we? Thank you. I'm like, where are we going now on our adventure in appeal land? Okay, so I guess we're going to closing arguments. Mr. Golden, I'm guessing.
I will keep it brief. If they'll agree to keep it brief, I don't have very long closing arguments. Mr. Swartz, keep it brief so we can be done. So I just want to bring the board's attention to the fact that it's been an excellent process. I appreciate all the work that the city did, and very rarely do I agree with some of the legal principles that the city puts forth. And Ms. Gillingham did, in her brief, identify certain statutes that regulate. 143-755 and I think she cited it as 160D 108, but it's 160A 385 based upon 2017. And those statutes do give the applicant the ability to choose. When the law changes after the application was submitted, they get the opportunity to choose. Do I want to go under the first rules when I submitted it, or the after the fact rules, right? You get that. And the important aspect of that is because Mr. Collins relied upon 160D 108E, and it says where multiple local development permits are required to complete a development project, this section authorizes the development permit applicant to choose the version of each of the local land development regulations applicable. I agree with that. They 100% I agree with what they're saying there, except that that's not the end of the law, right? This provision, the provision cited by Mr. Collins that we've all been talking about, this provision is applicable only for those subsequent development permit applications filed with 18 months of the date following the approval of the initial permit. We just talked about the approval of the initial permit. That zoning permit for 15 residential condos was approved in May of 2018. This provision that we've cited in the zoning determination letter is applicable only for subsequent development permit applications filed within 18 months from that day. We are here today because they have filed a change of use under 7-5-2 of the city's UDO saying we're changing our use from residential to lodging facilities. They had that choice 7 years ago. They didn't choose to make it. How do we know what their choice was? Because they put it in their zoning permit, 15 residential condos. Zoning laws aren't meant to be changed 8 years later. The Jackson Building could do this. They could come back now and say, There were no regulations in 1929 when I was built. I'm going to convert it to whatever. Zoning gives stability, and we've had stability, no short-term rentals over at 17 North Market Street for 7 years. Now, we've got this permit choice section that you had to make a choice within 18 months, where 8 years later, you would ask this court to overturn, not overturn, we would ask this court to make a determination that the applicable section of the ordinance that applies to this development regulation is item 4 in the record, ordinance number 4637, adopted on January 9th, 2018, which prohibits short-term rentals in the central business district. Why? Because 160D 108E requires it. Thank you.
Thank you, Mr. Golden.
I'll be very brief. Just to sum up the city's case, this is really quite a simple timeline. The applicant here submitted an application for a level 2 development before the ordinance that made short-term rentals no longer allowed in the CBD zoning district. The permit choice and vested rights statutes, which are in the record, both of those statutes for the board's review, and as outlined in my memorandum of law that I submitted, hold that by operation of law, not by what they put on their permit, but by operation of law, that timeline makes it so that they could use the use that was allowed at the time of the application, and they did. So that use is allowed. In the city's opinion, Mr. Collins described what he considered when making his zoning determination. He very carefully considered the use of the property at the time, when it had commenced short-term rental use, and the intent of the developer. He did not have to consider restrictive covenants. Those are beyond the scope of his role as an assistant planning director. And in fact, I have one case that I'll hand out to you. It is cited in my memorandum, and I'll hand it to the other council too. Before anyone points it out, I know that it says that it was reversed. But if you go to the very last page of the case, the Supreme Court actually reversed it based on the language in the dissenting opinion, and the dissenting opinion is what I have highlighted. So if you go to the highlight. Highlighted language of the dissenting opinion, which is affirmed as written, as you can see on the very last page of this, states, zoning regulations are not a substitute for private restrictive covenants. If the subdivision residents believe the petitioner's use of their property is unreasonable, their remedy is an action and nuisance, not to enlist the city as an accomplice by incessant complaints about their neighbor. In the city's opinion, any testimony today about restrictive covenants is just an attempt to loop the city in, as the case says, an accomplice to their behavior, and it is wholly irrelevant to this board's consideration. I have nothing further. Thank you.
I am going to sit here, if you don't mind. If I were to try to get up and out-gesticulate Mr. Golden, it would not go well. So we agree with the city. This is a simple matter. That same case that was just handed up, there's in the highlighted portion, says this: North Carolina's law says when there's an ambiguity in a zoning ordinance, it is to be resolved in favor of the free use of real property.
I like to call this the tie goes to the free use of real property, okay? So the questions before this board really, I think, boil down to, on December 14th, 2017, did the UDO clearly say short-term rentals were lodging? The answer is no. Did the UDO clearly say short-term rentals were anything other than residential? The answer is no. So construing any ambiguity there in favor of the free use of real property means that short-term rentals were allowed under the initial application and its residential designation. So as it was submitted. Gerald Green's testimony did not answer those questions any differently. He did not testify that short-term rentals were clearly lodging. He did not testify that lodging was always commercial. And he admitted that the current UDO, for what it's worth, defines short-term rental as residential in character because it uses the words dwelling unit. The appellants also talked about 160D-108E. They said a change in use could only be done within 18 months of the initial application. But there's a couple things about that. Number one, they only read part of section 160D-108E. They stopped right before this subsection does not limit or affect the duration of any vested right established under subsection D of this section. And second, 17 North Market Street's rights vested under the December 14th, 2017 UDO. That version of the UDO did not require short-term rentals to apply as a lodging facility. When we apply the tie goes to the free use of real property, residential covered it. So no change in use amendment was actually required, but the city asked us for one, so we submitted it. Finally, the evidence Mr. Collins considered and the evidence submitted before this board today covers everything required to establish vested rights under the statute that we discussed. The city said the UDO was ambiguous and the residential permit covered STR. The city investigated and established the continuity of the STR use. And there was a lot of noise about intent, but to the extent that's relevant to the statute at all, the affidavit of Charles Caputo, which is attached to the brief, which was put into evidence without objection, says short-term rentals were always the intent. So based on that, we simply ask this board to affirm the city's determination.
Thank you, Mr. Swords. Does this open up to public hearing at this point?
If you want to take public comment, this has been your hearing, but I don't know if this is one that the board can, is not required to allow public comment from the audience. But they got any personal thoughts.
Board, does anyone have any thoughts about that one way or the other?
Regarding public comment?
Yeah.
Anybody here?
I feel like everyone that is here is being represented by their attorney, and their attorney has well argued their cases today. But if anybody feels differently, please speak up. Okay, all right, great. Okay, board, I'll open it up to any questions you may have for staff or discussion.
I have one. For Ms. Gillingham, if you don't mind. Mr. Golden tells us that North Carolina General Statute, Section 160D 108, subsection E, I think, which has the 18-month rule in it, should apply in his case. And Mr. Swords is saying that 18 months is not so much applicable in this case. Could you please refresh our memory on what the city's interpretation on that section is?
I mean, I guess the city's opinion on that is that from a pure permit choice vested rights standpoint, and taking into account that ambiguous uses are construed in favor of the free use of land, combined with, and I would defer to Mr. Collins about what exactly he looked at when issuing the zoning determination, but the evidence that this was the original intention, stemming back from when the condos were first developed, that the use was commenced as soon as it could practically be commenced. I mean, the permit application was to develop the condos. They weren't used as anything until a certificate of occupancy was issued.
Thank you very much.
I don't have any further questions for anyone at this time.
Do you have any discussion you want to add or comments to the board? Anybody?
As I've said before, there's common sense and then there's law. You wish that they align, sometimes they don't. In this case, my opinion is that the city was correct within the law. Well, that's, I'm ready, I'm hungry.
I always appreciate your frankness, and that is something I really appreciate. Anybody else have any questions or comments or just general arguments?
Not from me.
Okay.
Not for me either. I affirm that the city is correct, and I would motion to move forward.
Okay, so having said that, you're in the hot seat. Would you like to make the motion? And the motion would be something along the lines of, you make a motion to uphold the determination of city staff?
I affirm to uphold the determination of the city staff.
May I get a second?
I'll second.
Okay, board members, when I say your name, please say aye or nay. Elliott Smith.
Aye.
John Michael Cletus.
Aye.
Annette Wise. Aye. I'm so sorry.
Aye, James Warnall.
Thanks, James Warnall. I always am drawing a blank on her name, and Suzanne Godsey is an aye.
You all enjoy your dinner. Thank you very much.
Thank you.
Thank you so much. Everyone, if you want to recycle your paper, find me. We can get that to a recycling bin. A lot of paper today.
Thank you. Okay, so if there are no objections, we'll close this meeting.
Yep.
Hearing none.
Absence.
Great.